May please your lordship. My lord, I pay for people lordship to be kind enough to leave this matter before these banks, my lord. Earlier, this matter was listed before single bench, and a single bench has passed order saying that the similar issue has been decided by this honorable court, so the matter may go before this matter will be listed before this court, my lord. So, my lord, matter will be taken up in the next week, my lord.
No, but whether the case has been registered as a DB case or not,
Not registered as a DB case.
then we'll find out. Let the file. How single bench can say that it should be listed before division bench? Single bench can't say so. We'll have to check this on the administrative side. We'll find out and then let you know. Come back at 2.
My lord.
Okay. Get the file. Which is the file? Let's see. Put it in the chambers. Put in the chambers. Yes.
My lord, I beg to mention item number 32.
Yes.
I am for the respondent number 5, my lord. My friend is for the appellant, my lord. With consent from my friend, my lord. Lordship may kindly join the matter for the day, my lord. Lordship fix the matter at any date, my lord, as per my friend's convenience, my lord. I am for the respondent number 5 in this case, my lord. I am seeking an adjournment, my lord. My friend has the.
You are for the appellant?
Yes, my lord.
Any objection?
No, my lord.
And counsel, Mr. Kalita, representing the respondent number 5, has prayed for an adjournment. Counsel appellant, representing the appellant does not object. List the instant appeal for hearing after 4 weeks.
Item number 29 and 30, Lordship.
Yes.
In this matter, counsel appearing and who is assisting learned advocate general, Lordship, is on bereavement, Lordship. So on his behalf, Lordship, I am praying for some accommodation.
Okay. Who is in bereavement?
His some family member died, Lord.
Whose?
The council, standing council, Fisheries Development Corporation.
All right. It is stated that the standing council for fisheries, appellant Fisheries Development Corporation is in bereavement, and a request is made to adjourn the case list after 2 weeks. The other side has no objection. List after 2 weeks.
Lordship, with regard to item number 33, we had circulated the adjournment slip yesterday, Your Lordship.
Okay, 33. Appellant's counsel has, you are for the respondent. Any objection?
Lordship can fix the hearing of the date. One thing I wish to indicate, there was a direction upon the respondent number 1 to file a status report. The direction was passed in January. On the last 2 occasions also they prayed for extension, manner. In the meantime, let them file the status report.
And counsel for the respondent, please for time. The counsel representing the appellant points out that the respondents were required to file a status report, which direction has not been complied. Thus, requiring the learned counsel for the respondents to place the status report on record in the intervening period, the hearing of this writ appeal is deferred by 3 weeks.
My lord, with the consent of the other side, I beg to mention item number 3. In this contempt case, I'm led.
Why can't we go page wise?
Thank you,
Yes,
Swami
3.
Lordship. And
Yes.
we pray for 3 weeks' time to file an additional affidavit.
On behalf of
The petitioner.
and counsel MS so and so, prays for time to file an additional affidavit on behalf of the petitioner. List after 3 weeks.
Would like.
I beg to mention item 34, my lord.
Just hold on, page wise. Yes.
Please, your lordship. Lordship, I beg to mention item number 21 for adjournment. But
Why?
the arguing counsel is down with COVID, who is from Delhi.
Down with,
COVID, your lordship.
it is stated that the arguing counsel is down with COVID. And a request is made to adjourn the case list after 2 weeks.
Lordship, the date may be fixed. He's from Delhi.
List on 18th May.
Well, item 34, my lord. In this case, I am for the appealant, my lord.
Here, my lord, we filed a review petition, my lord, there is a order, my lord, of this honorable court, my lord, on 22/11/2011. Some point was raised, my lord, to raise the point before the single bench. It is pending and it's on 9th of May, my lord.
And council states that a review petition arising from the very same judgment of learned single bench is pending consideration, and thus hearing of this appeal may be deferred. List up 4 weeks as per it.
File it, sir.
May I please your lordship? Lordship,
Yes.
with the consent of other parties, I beg to mention item number 35, lordship.
35.
Yes, lordship. Counsel for the respondent will not be able to appear today because lordship, his family member has expired, lordship.
It is stated, who is the counsel?
P. Sharma, standing counsel. lordship.
That Mr. P. Sharma, standing counsel for fisheries department,
Yes, lordship.
is in bereavement and a prayer is made to adjourn the case on his behalf. List
Yeah,
up 4
For
weeks.
the appellant, lordship, finally, may I pray for a fixing a death in the month of May? lordship?
List for hearing on 1st June.
Obliged, lordship.
Regard to item
Obliged, lords.
33, my lord, my learned friend just mentioned, a spraying, my lord, may it be listed on 18, my lord, because I'm not
18th
a
May,
local
all right.
council from here, my lord, that is the
18th May.
18. I'm obliged,
Ah.
extremely obliged.
Sir, I'm a-
Madam Mayor, please your lordship. There was a matter listed today. 31 from Nagaland bench. The urgency was there. There was no benches were being constituted in the matter. This is service matter, and because of the stay order of the petitioner,
Mm,
I am supposed to be I am supposed to be get promoted, but my entire cadre, my technical wing cadre
uh,
has been held hostage.
Mm.
Now my friends have come from Nagaland. Yeah, oh, Mr. Sir is going to lead the petitioners.
mm.
He's been freshly engaged, and I have been told by the Mr. Ken Chaudhary sir is also going to lead in one of the.
Mhm.
Lordship, we are-
What do you want?
No, sir, we on the next date.
It's listed today.
This is
At
listed
serial number,
31.
31.
are you agreeable to the request for adjournment, sir?
Yes, my lord, I have not received in fact, next week only I'll be able to.
A
file
joint
the-
request is made by land council representing the parties to adjourn the matter. List after
2 weeks, my lord. 2 weeks.
2 weeks. All right.
All right.
Attendance mark कर देना सबका.
Lordship, may I present lordship, lordship, I pray for listing of our matter, lordship.
What matter?
Lordship, we have sent an order passed by the learned central administrative tribunal, lordship. Lordship pertaining to a transfer matter, lordship.
Okay, first. Get it listed on first.
Lordship. Obliged, lordship.
Please, lordship. Lordship is similar prayer, lordship, we have challenged the rule, lordship. APDCL service manager.
First.
Lordship.
Doesn't matter. Let it come up. Let it come up. No, first. Second. All right. First is a leave holiday. Is second.
Item number 1 for orders.
PIL. What's the PIL about?
Lordship, may kindly pass over the matter for the time being.
What is the PIL about? What is the matter coming up for orders?
Lordship, it relates to shifting of.
Status report.
Already FR has been filed, submitted, my lord.
FR has been submitted. What is the prayer in the PIL?
Lordship, it relates to shifting of two Gao Panchayats from Lakhimpur district to Bukwakina.
Shifting.
Lordship,
Why PIL for that purpose?
Lordship, because they didn't want the shifting from Lakhimpur
So
district.
they didn't want is not the ground on which the shifting of panchayat can be interfered. Is there a stay?
Yes, Lordship.
There is a stay of this court.
Yes, Lordship.
Are you prepared, sir, to argue the matter?
Lordship, in this matter, additional advocate general is appearing, my lord.
Where is he?
He is not yet, because of some personal difficulty, my lord, not yet reached, my lord. At 2, my lord. If possible, my lord.
Who would be arguing? P. Sharma? No.
My lord, K. Kumar. K. Kumar, additional advocate.
K. Kumar. Mr. So and so has placed on record the factual report forwarded from the office of SP Lakhimpur, North Lakhimpur, regarding status of PS case number 179, 2016 PS, the Khana, a perusal of the report would indicate that after repeated rounds of investigation, the police has filed a negative final report in the court concerned. List after 2 weeks,
Well.
list on, fix a date because there's a stay, 15th May. Yes,
Highly obliged, my lord.
Matter number 2.
Lordship, reading is completed in the matrimonial appeal. Section 25 petition is pending.
section
Yeah.
25.
Lordship, they agreed to give us 50,000, 15 lakhs of rupees.
How much?
15 lakhs, they have agreed to give us
15.
15 lakhs,
Yes.
whereas. the
When was
petitioner-
this agreement arrived at?
No, Lordship, it is a too bigger amount because he has to stay there for a long time. He has to remain,
Okay, so the appellant is not agreeable to that
it
amount.
is not agreeable, Lordship.
So then we'll list it for hearing then. Also 25 has to be decided.
Lordship,
All right, argue then.
Lordship. The divorce was granted on the point of that, yes, this petitioner has deserted the husband.
Hmm.
I have given explanation of that desertion.
But
Because
that
the-
explanation, whether we can go into it once the,
Lordship, not-
with
that
the
case-
findings of the
Lordship,
divorce
Lordship.
case are final.
Lordship, in that case, I'll go only on the for section 25 petition.
On,
Section 25 petition,
yeah, all right, argue please.
section 25 petition, we have stated that
What is the age of the parties?
parties 40 years. Other side is,
Hmm.
and she has a minor daughter, has it about 11 years.
Okay,
She is a permanent asthma patient. She is a patient of asthmatic trouble.
okay. Is
My
your
God.
mic switched on, Mr. Counsel? Can you switch on your mic? The mic is not working or what? On, okay, yes,
Lordship,
yes,
she is a asthmatic patient by
okay.
birth. And she is continued to be under treatment of this.
Was any application under any other statute filed seeking maintenance ever 125 DV Act?
125, it was filed during the pendency of the divorce proceedings.
What happened?
It was granted, 8,000 rupees was granted at the time,
8,000
8,000.
to both mother and daughter.
Mother and daughter.
What
Thereafter,
happened?
We filed a petition under section 24 of the Hindu Marriage Act.
Hmm.
And after hearing the parties, 15,000 was allowed,
15,000 per month.
per month was allowed. So
Okay,
Lordship, my
so that
submission,
total comes to 23,000
no,
per month.
Lordship,
Why?
that is,
That has been adjusted.
discontinued. The moment
125 has been discontinued.
Discontinued.
Okay,
Lordship, my submission before this honorable court is that 15,000 into 12 months, another 20 years of age, 20 years of period. So it comes about 36 lakhs.
Hmm.
So, and he's in a position to pay that amount. And
He
he's
wants to
but-
pay it in installments, monthly installments. Why are you bothered? You talk about your application. He is not ready to give anything beyond 15 lakhs.
Lordship, in that case,
I'm ready
That
to pay
he-
15 lakhs, your lordship. 15 lakhs, I'm ready to pay.
15 is nothing, Mr. Counsel. You have a minor daughter to maintain.
Your lordships,
What does the appellant do? Well, your
he's a medical
He's a
representative.
medical representative. your lordship.
So 15
And
lakhs is
earning-
pittance.
His
earning
income is
54
shown as a 67,000.
Yes.
Mother is a railway, mother is a family pensioner.
Mother is not liable to
No,
pay maintenance to these
Lordship.
people. Yes.
So he doesn't have any liabilities. He now at present, he is a married. Second marriage is already contracted during the pendency of the appeal.
Okay. All right.
Therefore, there is no question of going back to the family where there is.
So
already a
read the
release.
findings in your section 24 application. What are the findings regarding
Section-
income?
Section 24, that petition has been 67,000 was given. 67,000 on the 67,000.
Lump sum,
is Lump sum 67,000 was shown as the income.
right?
And it was, there was a deduction of 12,000 rupees, as he said, for the house building loan.
Okay.
Whereas from the statement, it shows that that is a government land. So there can be no building advance towards a government land. Construction of RCC building over the government land. But
Mm.
there is an existing RCC building, two-story building. And there is a, what is that called, rented shops also. And maybe what is, some persons are given as their tenant also.
Where is the order, sir? Where is the order of 24?
Section 24 orders, we have not employed, but is with the record. I'll.
Oh, But this is simply an appeal against the grant of divorce.
Yes, Lord.
Lordship,
Where is your application under 25?
section 25 petition 366. 366 2022.
Let's see, let's see. So we need to have that order of 24. How do we appreciate evidence in this case?
Lordship. I have the copy.
So you should place on record. Place that order on record.
Lordship, and I will buy.
The council, IA number so
Your
and so.
lordships, there is a question of mentality of section 25 petitions.
Why?
Because the lordships, till date, this degree which has passed by the trial court, stayed by your lordships. So.
Decree
there is
of
no degree at
divorce.
all, Yes, your lordship. And permanent alimony come after the degree accepted by the opposite party.
No, no.
He has not
Where do we get
accepted
that
the
from?
release.
Read the
Section
provision.
25 clearly says before or after,
Read the provision.
section 24.
Yes,
Thank you.
read.
Section 24, section 25. Section 25 clearly states any court. Section 25. Permanent alimony and maintenance. Any court exercising jurisdiction under this act may at any time passing a decree or at any time subsequent thereto an application to it for the
No,
purpose of
decree
either.
thereafter. How does it matter?
Degree, your lordships, degree in this,
You raise an objection of maintainability and we'll dismiss your application.
your lordships.
Your argument of maintainability, dismiss, argument is
Your
overruled.
lordships, Further, my argument is that your lordships, in
Your-
fact, this
ask
is the
your-
original application under section 25, it ought to have been filed before the trial court, your lordship.
24 was filed before the trial court, 25 has
your
been.
lordship. The application has been filed 25 under section 25.
Yeah,
permanent
so
element.
but why can't it be filed in the appeal?
Any court,
But
including
any
appellate
court, your
court.
lordships, your lordships. the
Was there
section-
at 24 in
Section-
the trial court, sir?
Section 19
Mr.
of the Hindu Marriage Act maybe.
Was there a 24 in the family court?
24 is the.
Is your client
regarding the
paying-
Maintenance mandate like.
Is your client paying? Did your client pay the amount?
I'm paying 15,000 your lordship per month, as per the order of your lordships made under section 24.
Hmm. All right.
So he came under 25 your lordship.
You raise whatever arguments you want to raise next date. We'll consider
Lordship.
your arguments.
There is
Your
no
lordship.
point of going back to the family again. So even if
Then you
my
accept.
matrimonial appeal is allowed, I cannot go back to the family where there is already a lady staying. Therefore, I have abandoned that petition by appeal. So I may be given at least section 25 petition relief.
You place that order on record.
Lordship.
And counsel for the appellant shall place on record the certified copy of the order whereby the application under section 24 filed by the applicant herein was decided by the family court. List. Copy of the order shall also be provided to
Section 24 petition has been filed, decided by this honorable court in division.
this
bench.
court.
Lordship. It is order is
Already there.
already there.
Where is it? You know? Yes, then there will be a question, Mr. Counsel. Then whether once 24 has been decided, then further 25 in the same appeal,
Because section 24 maintenance pendency like. Now I have abandoned that.
pendente light means what the decree of divorce was granted by family court.
Lordship,
You filed an appeal.
lordship,
That appeal was pending and you filed an application under section 24.
lordship,
That has been decided.
lordship, that has been.
So
issued.
then are we now reviewing that order or what?
Because the situation, new situation has come because he is already remarried during the pendency of the appeal. Therefore, I cannot go back.
Who
to the
says
family.
so? Who says so?
He has agreed, he has admitted before the honorable court.
Your lordship, he has filed nothing to show that I am legally.
He has
married.
admitted before the honorable court. that is
Where?
it.
Where has he admitted?
He
Tell
before
us.
this honorable court on the other.
Oh,
day,
in which proceeding, sir?
Lordship, there is no proceeding. You have not done
Then-
any proceeding.
Then your oral submission is absolutely worthless.
He has admitted before this honorable court, yes, he was, other question was put to him, whether you are married.
Sir, is it recorded anywhere?
So,
Then-
lordship, it is not,
That is in the realm of unknown. We are not relying on that.
lordship.
So 24 is decided. Why
Lordship.
25? 24 decided by this court. And why 24, 25 again?
24, because we cannot go back to the family now, because the situation is when he has.
That is your decision. He says that he will keep both.
Lordship, if that.
We'll get the
that- that
divorce
can be per-
reversed,
if that
get the
can be
decree of
permitted-
divorce set aside and he'll keep both.
If that can be permitted,
Oh, keeping two women is not an offense. Maybe marrying two women is an offense.
no, lordship, that is, he has married. I am already married because my divorce.
So he has married after the divorce was
Yes,
granted. What is
Not-
wrong
not-
in that?
Not before divorce has been granted, but within 1 month. That is, I have
that-
filed that appeal
Then
within 1
get a
month.
declaration that the marriage is void.
That's subsequent because he has not come. I'm only stated I have given the names and the details of the lady also.
Then you can either sue him for contempt.
Lordship, there is other provision also that can be.
So use that provision. For the present, the 24 has been decided, sir, by this court. This court has fixed the quantum. What is the reason for announcing that quantum now?
Not I am announcing, I am only asking for that, yes, I may be given permanent alimony so that I do not have.
No, he is not ready to give permanent alimony. What to do? He has offered his 15 lakhs. You are not agreeable.
In that case, the maintenance amount can be made, section 24 petition can be enhanced that amount,
So you file that application.
Lordship.
So withdraw this. This IA, what is the use of this?
I'll have to consult my our client also in this case.
Counsel for the appellant, prays for time to seek instructions. A list of 2 weeks.
Much pleasure. Matter number
Uh,
4.
Take note, counsel for the respondent has raised an argument regarding non-maintainability of this block reapplication under section 25 of the Hindu Marriage Act on the ground that the applicant has already sought for an order by order of maintenance pendant alike by filing an application under section 24 of the Hindu Marriage Act, and that the respondent is paying her maintenance amount to the tune of rupees 15,000 per month in terms of the order dated so and so. That's the order in 24. He thus urges that the instant application under section 25 of the Hindu Marriage Act is not maintainable. Counsel for the appellant prays for time to complete his instructions, list after 4 weeks.
Much pleasure, Lord, sir.
Okay.
Matter
4
number
weeks.
4.
May it please your lordship.
Yes.
This matrimonial appeal, lordship. Initially, I have filed one application for restitution of conjugal life, lordship. That was dismissed. Against that, lordship, I have filed this present appeal. And on last occasion, your lordship has directed for conducting a mediation.
Mediation has failed.
Yes,
lordship.
my lord, report
Okay.
has come.
Report has come, all right.
Yes, your lordship.
Now, argue on merits, then proceed. What
in
is your
view-
appeal about?
in view
Appeal
of the-
against
against
rejection
the-
of divorce,
Lordship.
So
Not-
restitution
not
of
divorce,
conjugal
restitution of-
restitution of conjugal
Yes.
rights. Oh,
Mediation has failed, so your lordship may close the matter because lordship, she do not want to come to my, with me, lordship.
so you want your appeal to be disposed of
So that may be closed, lordship.
in view of the fact that the mediation proceedings undertaken between the parties have failed as per the report dated so and so, comma, then counsel for the appellant submits that this appeal, the appellant would no longer be advised, can no longer be advised to continue with this appeal in view of the submission noted above, comma, the instant appeal, MAT appeal number so and so is disposed of.
It may be dismissed, my lord.
So
He's
it
not
may be
pressing for
disposed
it,
Doesn't make any difference. To file an execution, how will you get the decree executed?
lordship.
Do you have any means?
I don't have, I have,
All right.
lordship, I have 2 sons, my lord, minor sons, my lord.
That's all right, but how will you get the decree under section 9 executed?
Obliged.
LCR आया है क्या? Be returned और फिर जरूरत नहीं लिखना. चलिए next.
Matter number 5.
May I please, your lordship?
Yes.
On the last occasion, order was given to take steps upon respondent number, upon this whole respondent. So now respondent have appeared and they have filed their.
You are appearing
I'm appearing for the
and
respondent.
counsel Mr. So and so appears, puts in appearance on behalf of the sole respondent. Okay, so that direction to get it served through the director worked seems so. Service is thus complete. List for admission,
Your lordship.
Your lordship, in the first week of June, if it's possible for the summer.
first week of July,
June.
June, in the first week of June as prayed. LCR is here. All right. This is against grant of divorce.
Yes, lordship.
So we'll admit the appeal. What is the problem then?
Yes, your lordship.
The appeal is admitted. The respondent is duly served, so notice need not be issued. List for hearing in due course.
Lordship, any date may be given.
It will come up in routine.
Okay, ma'am.
Item number 6,
Obliged.
Yes.
Lordship, the issue that I have raised in this PIL, that the excise department has taken an initiative to establish a wine shop in a residential area. It
Okay.
is a thickly populated residential area. The local people have raised their complaint. It has not been solved as per the rule. And this initiative has been taken.
Is there any prohibition that a shop
Yes.
of excisable articles can't be set up in a residential
Yes,
area?
yes. The excise rule says that.
Read.
Lordship, today I don't have the excise rule, but I can remember the rule 293, rule 294. Rule 294 says that before establishing any excise shop,
Mm.
a inquiry has to be conducted, and if the inquiry establishes that such excise shop is necessary in the public interest, only then such shop can be established. And the amendment rule 293 says that the resident who are residing.
What is the address of the shop, sir?
It is in Lakhipur town of Gwalpara district.
Rongsai Bazaar.
No, Lakhipur town, Lordship.
Read your para 10. Page 10 of your writ petition.
Page 10.
Yes. Below subpara B. About 8th line from top.
Which paragraph, Lordship? Paragraph number 11.
But in the instant case, no local inquiry was conducted. Page 10 of your writ petition.
That the petitioner states that another resident of the. ward-
Above that, but in the instant case. Have you got it, sir? It is from the top. About 7th line from the top.
Paragraph number 9.
This is a part of para number 12, sir.
Part of paragraph.
Running
12.
internal page 10 of your writ petition.
Internal page 10, yes, that's it. But in the instant case, no local inquiry was conducted as per the mandate of Rule 294 of Assam Excise Rule 2016 to justify that action regarding grant. This Lordship, I essentially apologize that Rongsai Bazaar, it is a typological error. It has.
We
to be
don't know.
Lakhipur
We go
town.
by your pleadings. You say that it is in a residential area. Your pleadings say it is in a bazaar.
It is a market area, that is true. But the
Market
name-
area, then where is the question of a residential area, sir?
It is a Lordship, it is a small village market.
So,
That
what
is
of
the-
that?
And the one side is a town committee, entire area is a town committee, but where the shop is going to establish, it is a residential area. There is no shop.
No, Lordship.
And issue is that.
Your
Lordship,
own
I
pleading,
can-
sir, says bazaar. What do you mean?
Bazaar, Lordship, yes, that is a town committee area. And Lordship, my submission is that the excise rule 294 clearly says that
Hmm?
an inquiry has to be conducted by the authority to establish that such action is necessary in the public interest. And no such inquiry was conducted. And Rule 293 says that, Lordship, if any resident who are residing within the 75-meter radius of the proposed site, if they raised any complaint, their complaint has to be considered. And this is not considered.
May I please, your Lordship?
And Lordship, on last occasion,
Lordship,
I'll come.
Inquiry has been conducted by the inquiry officer, Lordship.
Your reply affidavit says so?
Yes, Lordship, I have, my affidavit is ready, Lordship, but
Your-
the deponent has decided.
Whose affidavit is there then? This is a affidavit in a position by Ajay Kumar Bayan. Whose affidavit is that? Excise officer, superintendent of excise.
Lordship, that is my first affidavit. Now.
You want to file a fresh affidavit?
I have-
Lordship, may I interrupt on that issue? Lordship, they have filed the affidavit and that.
Inquiry has been conducted, Lordship. After that, or also.
No, council MS so and so representing the case I kya? Excise department submits that she is desirous of filing of
Additional.
an additional affidavit, bringing on record certain new certain facts which could not be incorporated in the earlier affidavit? Or you want to bring fresh facts?
Yes, sir.
Inquiry was conducted subsequently or prior to grant of license?
13th of December 2022, inquiry was conducted.
After filing of this PIL,
No, Lordship.
then that inquiry was conducted before you granting the license, after granting the license?
And my lord, may I add?
Yes.
For the private respondent,
Mm.
no license has been granted, only an application has been
Application
submitted.
Till date, license has not been granted.
Like, my lord, they had,
Is there also filing an additional affidavit? Needful.
they had put forth their objection, my lord, the excise department in their affidavit, my lord,
Okay.
have already.
Is there a stay by this court? Is there a stay?
There is.
All right.
Lordship, in this case, Lordship, on last occasion, they have filed the affidavit, learned, this honorable court was not satisfied and personal appearance was given, where their officer appeared. Thereafter, this court directed them to file another affidavit.
So all right, let the affidavit come. Would be filing an additional affidavit within next 7 days. List on 12th May. Okay,
Lordship, I may be allowed to correct the mistake that Rongsai Bazaar, it will be Lakshmipur Market, Lordship.
we'll see. Yes,
Lordship.
do that on an affidavit. We will not permit you to do this now in this petition. That is a very material fact which is apparent on the face of the record in your petition. So if you want to do it through an affidavit. You
Lordship,
have to file an amendment application.
Lordship.
Yes.
Matter number 7.
Obliged, Lordship. Obliged.
May I please, your lordship? Lordship, a service report is awaited, my lord. We took steps to dusty service, my lord.
Affidavit, you,
Affidavit, my lord, that acknowledgement receipt, we could not trace it, my lord. If your lordship will allow to take us fresh steps, my lord, we'll.
all right, land council for the appellant submits that the acknowledgement receipt has not been received. And thus, the appellant is required to take fresh steps for serving the response number 3 and 4. Requisite steps be taken within 7 days, whereupon, fresh notices be issued to these respondents. Thus, the service is permitted. Rule is made returnable in 5 weeks thereafter.
I'm obliged.
Matter number 8.
Lordship, in this case, by order dated 1st of March, Lordship directed the registrar to make inquiry whether service is completed. By order dated 19/4/2023, Lordship
Service
deputy
is
registrar
complete.
gave a report that service has been completed duly. But nobody has appeared, Lordship.
All right, the office note dated 19/4/23 indicates proceeding of the Lavazima court dated 19/4/2023 indicates that service has been completed upon the sole respondent. No one has appeared on behalf of such respondent. List for admission.
Lordship.
After 2 weeks.
Matter number 9.
Yes. What is the contempt?
Yes, Lordship, now they have come up with an affidavit with the statements therein are contradictory, my lord.
What is the order under contempt? Let's read that.
Order was they were directed to complete the process of selection to the post of director of the Directorate of Geology and Mining. And thereafter, Lordship, by the further order, gave them 2 months time to complete the process. Now, my lord, affidavit in opposition has been filed by the respondent contemnant number 2. Now, in para 4, he says that the government has initiated the process of selection for promotion to the post of director. Para 4. But that again is qualified by the statements in para 3 saying that now they want to bifurcate the directorate.
Let me read the para 4.
Where is your affidavit? It is not come on record.
Sri Orpon Soikia, the affidavit has been filed by Orpon Soikia on 11th of April.
All right, 21, page 21. Yes.
paragraph 4, kindly come to paragraph
Mm.
please two. The deponent respectfully states that in terms of the direction of the honorable court, as per order dated 23/2/2022 and the order dated 17/8/2022, Mines and Minerals Department has initiated the process of selection for promotion to the post of director in the Directorate of Geology and Mining Assam by directing the Director Geology and Mining to submit the details of the eligible candidates by this office letter number so and so dated 4th of November 2022. However, in the meantime, the department at the highest level wants to bifurcate the existing Directorate of Geology and Mining by creating two separate independent directorates, namely Director of Geology and Director of Mining, wherein the technical scientific work shall proceed under the Director Geology with all personnel under the Director Geology and administrative responsibility, license, permit, etc., including revenue collection shall be with the Director Mining, who shall be from the administrative IAS, ACS background. The deponent respectfully states that although the government desired to take the aforementioned steps by bifurcating the directorate in view of the honorable court order dated 23/2/2022 and 17/8/2022, whereby the honorable court has directed the state government to initiate the process of selection for promotion to the post of director in the Directorate of Geology and Mining Assam in accordance with law. The government found it difficult to initiate steps to appropriately amend the
That you have proposed a review be filed. What happened?
Malab, that review has been filed. Malab, on 19th of 4, Malab, we have filed the review. Malab.
File a review.
Yes, yes, we have.
Let the review come up first.
Lordship.
All right, then the government council, Mr. Lal submits that a review application has been filed seeking clarification of the order dated 23rd March 2022, of which contempt is alleged by the petitioner. The consideration of this contempt petition is deferred by 4 weeks, during which period, the review application may be considered.
Obliged, Lord.
Item number 10.
May I please, Your Lordship? I am on behalf of respondent number 1, the petitioner, my lord. I have filed an affidavit in opposition to the additional affidavit filed by the appellant. That may not be in record. Today I have fetched,
You file it today?
Lordship. That matter will come up on third week of May, my lord.
Your Lordship, I pray for a date, Your Lordship, 18th of May, Your Lordship, which is a hearing day as well, Your Lordship.
Then council MS, what's your good name, madam?
P. Bora.
Pibora has filed an affidavit in opposition
Yes,
on behalf of the respondent. All respondents
1.
or respondent number 1. The registry shall bring the same on record. The matter shall be re-notified when?
On 18th of May, Your Lordship.
18th May.
Much obliged, Your
Item
Lordship.
number 11.
Notified for admission on 18th May.
May I please, Lordship. Lordship, the service was not completed, but today itself, it will be taken, Lordship. Steps, Lordship.
Council for the
Extra
plan to
copies.
take steps for effecting service upon the respondents within 3 days. They're all government officials, no?
Lordship. Extra copies, Lordship.
Commissioners are there.
1/2/2023.
Upon steps being taken, let Dasti, you need Dasti services? Do you need Dasti process?
Lordship, extra copies to the department.
The service be effected, since all the respondents are government officials, service be effected by providing extra sets of writ petition to the learned standing council, respective standing council. List after 2 weeks.
Deeply obliged.
Item number 12.
This is a delay consideration application, my lord. The delay is of 94 days, my lord.
94 days.
I have given the explanation in paragraph 6 of my application.
Yes, please. Any objection?
We met with an accident, my lord.
All respondents are represented.
No, my lord, I am appearing 1, 2, 3, 4, 5, 8, and 9.
4, 5. Finance,
4, 5, 8, and 9.
finance, Mr. Nayak would be there. Who would be there for finance?
PWD also is there.
PWD. Copies of the interlocutory application be provided to the net standing counsel for the respective departments whose names shall henceforth be reflected in the call list after 1 week. List for orders after 1 week. Names are referred, WPT, Finance, PWD. So who are there?
WPT is also a separate standing counsel.
But the reference is given,
We have sub copies, my
the
lord.
copies have been served.
PWD. Therefore, call it. Dipankar Nath is coming, my lord. Senior government advocate.
We may condone the delay. It's on the ground of injuries suffered. IA number so and so has been filed seeking condonation of delay of 94 days occasion in filing of the corrected writ appeal against which has been filed against the order dated 5/12/22 passed in WPC number so and so. None of the respondents have filed any objection to the prayer for condonation of delay. Otherwise also delay is explained on the ground that the appellant met with a road traffic accident and was under treatment for a significant period of time pursuant to passing of the order. In view of the above, the delay is condoned. Interlocutory application is allowed and the delay is condoned. Registry shall number the connected writ appeal and list the same for admission after 1 week.
Item number 13.
Lord, in this case, there is a delay of 25 days in filing the writ appeal. Lord.
You are appearing
Yes, my lord.
elementary education.
Yes, my lord. Respond number 1 to 4. my lord. Respond number 1 to 4.
Should we condone the delay?
My lord, there is a private party, I should.
There is a private party, then notice will go.
Yeah, my lord, that's why I want to.
Issue notice of the interlocutory application. MS so and so appears for the respondent number 1 to 4.
Yes, my lord.
What about this requisite steps for effecting service on the respondents numbers 5 and 6 be taken within 3 days?
Five government can take, my lord. Deputy-
5 would be appearing.
By deputy commissioner. District scrutiny committee. It is represented by deputy commissioner of the concerned district, my lord. Only 6. my lord.
So and so appears for respondent number 5.
Yes.
Ms. Nath, you will be appearing. Deputy District Scrutiny Committee represented by Chairman come Deputy Commissioner Morigaon.
He can-
Should be the Education Department, most likely. Scrutiny of what?
Scrutiny of provincialization, my lord, of the.
Provincialization.
Yes, my lord. Recommendation for provincialization.
Find out who will be appearing. The steps for effecting service on the respondent numbers 6.
I can appeal.
DC की तरह आपके हाजिर लगा दिए. 6 be taken within 3 days, whereupon process be issued to such respondent. Rule is made returnable in 4 weeks. This is notice of the IA only.
My lord, extra copies.
Extra copies of the interlocutory application as well as the writ appeal be provided to. Interlocutory application be provided to counsel representing the respondents.
Item number 14.
Service on whom?
Respondent number 4, I have taken steps. AD has not returned back.
Has not,
Returned back.
has not returned, so we should await.
No, I have taken steps on 23rd March,
Okay,
1 month is
on
elapsed.
23rd March.
Presumption as regards service can be drawn.
But it is sent, I think, on 20th of April by the court. I have taken steps earlier.
issued on 20th April.
Yes.
So we'll have to wait till 20th May. Await return of notice issued to the respondent number 4 till for another 2 weeks, another 3 weeks.
Lordship may kindly fix a date.
List on 24th May.
Item number 15 for fresh admission which day?
Lordship, this deed has been filed after receiving the eviction notice, which is at page number 14. It was issued by the recovery officer of the DRT. On the footnote of it, there are properties too. There are A and C. There is no B1 actually, A and C. Now, we don't have any objections with the point, with the schedule number A. We have
Judgment, Rupam, that surface judgment. See the judgment, sir. Why the writ petitions are to be entertained. See this judgment. Pass it on to the Learned Counsel. Yes. The Supreme Court has come heavily down on the High Courts who are entertaining writ petitions in these matters.
Lordship, I could like to say that this is not under the Surface Act actually. This is the face of this one actually. If you come to my Lordship, if you come to same page on page number 2.
Of?
Same page, 14
Yes.
number actually. In terms of section 25 of the Recovery of Dues and Bankruptcy Act 2016, this notice was issued on the Act of Recovery of Dues and Bankruptcy Act 2016.
Okay.
Whereas this act actually of this Insolvency and Bankruptcy Code 2016 of section 25 says about the resolution profession. This on which act it was
That
stated.
would be if any of the debtors files an application for resolution, then it goes to the NCLT. Without that, why the proceedings will be under the code?
True, my lordship.
This is the
but-
bank who has filed the application for recovery of its dues.
True, my lordship, but here the NCLT will not come into the picture because this is not a company.
Right.
This is
The
not a
individual.
company.
This is an individual.
firm.
Right.
And every process was done. Everything was done under the Recovery of Debt to Banks and Financial Institution Act 1993.
Okay.
And this suddenly this notice comes under the different act and under different section. My lordship, you could be say you
The
could see
earlier
that-
proceedings, sir, the earlier proceedings are not challenged by you. Read this notice for eviction. There are so many earlier proceedings.
Here, the main fact which we are highlighting here with is, it has been not been challenged at there. This is a new point actually. This is a basic point because they have annexed thinking that it is the guarantor's property. Whereas he was not the guarantor from 2015 onwards. Because that's why actually I could like.
Go
my
and show it to
lordship-
the DRT. Go and show it to the DRT that you were not the guarantor.
Lordship, at the DRT level, this point was never came in the picture because.
Why did you raise it?
because-
Why did
Because
you
my,
raise it?
because my lordship, she being an ill and she does not know ever anything of this one. And she, after receiving this, the notice for eviction dated 23rd of March 2023, then only she came to know that all her signatures was a fake one. All her signatures from the
Are we going to
2000
that issue in writ petition? Anyone can stand up and say my signatures on the mortgage deed. are
Yes, my lordship. Yes, my lordship.
File an FIR. for
Anyone
the-
can say, but my lordship, I have attached the proof in page number 15. I have attached. I have
What proof?
attached here.
What proof?
Here in 2015, page number 15 in dated 4/10/2015, the letter in which the petitioner husband, who was the proprietor, has written to the bank. If you come to the second paragraph, again, I want to inform you that at present, my
you-
guarantor.
That was a unilateral act, whether the bank accepted this letter of changing the guarantor. No.
Yes.
Where is that
Accept-
acceptance? Let's see.
See, here we have stated that release her and take him.
Whether
And
the
it was
bank-
done. Yes,
bank is accept-
yes, my lord. And page number 16. In
Read.
page number 16, when the account was restructured, new fresh papers was made. Then in the page number 16 and page, this is the terms and conditions of restructuring of loan. In page number 17, you can come that the signature of my son who has been replaced by me has put his signature on the co-borrower. Click it.
because this loan of 2013 got restructured in 2019. And I was relieved from my guarantorship on 2015. And in 2019, when it was restructured, all the papers. were
Sir,
made
question
effect.
here is, this is your unilateral act, whether the bank has accepted your prayer. Let us see that. Where is the
But-
acceptance of the bank to this application for restructuring filed by your client?
But Lordship, isn't it also true? If they have not relieved me, then why have they also included my son? My son was never into the picture at the time of loan. I have annexed the proof. And on page number 31, last page, where at the time of loan, me, personal guarantee of Mrs. Hiran Bala Kalita was there.
Hmm.
So if this letter was not to be entertained, then I should have continued. Na? I should have continued.
Hmm.
So
Then-
now the thing is that there is no thing that I will also be a guarantor, even if my ill health, he will also be a guarantor. That cannot be done. Na?
Sir, how do you say that your son is also being proceeded against? From where do you say?
Because after 2015, every document of the guarantorship till 2019, when the account was restructured afresh, all his signatures was there.
Where are those documents? Are we to see those in a writ petition, or you are going to go to the DRT and show them that the guarantor has been replaced? Please withhold your action against the person who is no longer a guarantor. It's a question of fact now.
Lordship, why I came for this read actually,
Yes.
because this lower court under the section 34 actually, they cannot stay this one. And I have to go.
Gentlemen, whether you have ever taken such a plea that relieve the guarantor, the earlier guarantor, she has already withdrawn. Where is that plea before the DRT? It shows that plea.
Sir, Lordship, that plea was never ever raised.
Then why
I do
are we
agree.
supposed to entertain this plea
No,
for the
yeah.
first time in a writ?
Lordship, that plea was never been agreed because because till 23rd of March, from 2015 till 23rd of March 2023, this lady was never into the picture.
That is your assumption, sir. You have not placed the documents. Where are the orders passed earlier? You have not placed the documents on record. File all documents. We'll see. This is
Okay.
not fair.
Lordship, please give me some more time so that I can place additional documents over here.
Counsel for the appellant, after arguing the matter for some time, and counsel for the petitioner prays for and is granted 2 weeks time to bring additional documents on record. List after 2 weeks.
Item number 16.
May I please, Your Lordship?
Yes.
My Lord, petitioner before your Lordship, my Lord, challenging the order passed by the respondent, my Lord, for my Lord, under section 3(1) of the Prevention of Illicit Traffic in Narcotic, Drug and
PIT and
Psychotropic.
DPS. It's a detention under the PIT and DPS.
Yes, my Lord. My Lord,
Where is the
here,
order?
my Lord, order, my Lord, at page 34, my Lord. He was, my Lord, found, my Lord, with the interval of, my Lord, more than, my Lord, 6 months, my Lord, and last case was before more than 1 year, my Lord, regarding, my Lord, small quantity, my Lord. In 3 cases, my Lord, he was
As a
found,
trafficker, small quantity would not matter.
and my Lord, 6-month punishment, my Lord.
Punishment.
Yes, my Lord.
Ah, it's not a punishment. This is
Yes,
a
my Lord,
preventive detention.
Yes, my Lord. So, my Lord, brief of the, my Lord, all those cases I have, my Lord, summarized at page 6, Lordship. Kindly
This is a continuous course of conduct which brings about the detention order so as to prevent his nefarious activities in future.
Yes, my Lord.
Detention is meant for this.
Yes, my Lord.
What is wrong in the order? Let
My
us
Lord,
know.
Lordship, my Lord, kindly, my Lord, your Lordship may be pleased to have a look, my Lord, at page 6, my Lord, of my petition, my Lord.
Yes.
My Lord, I have given the summary of these cases, my Lord. My Lord,
Uh,
first case was, my Lord, the Hailakandi.
Sir, Just tell us what is your ground for challenging the detention order?
My lord, the ground is that, my lord, this detention order, my lord, vis-a-vis these three cases, my lord, not warranted, my lord. And last case, my lord,
Sheikh Nizamuddin versus State of Bengal, a single case of theft was considered as a sufficient ground to cause disturbance of public order.
yes, my lord,
And that was, the order of detention was affirmed.
yes, my lord,
So your number of cases is not relevant.
yes, my lord.
What is relevant is the conduct of the man over a period of
Yes,
time,
conduct, my lord.
which is
Last-
likely to cause grave
Yes, my lord, the
effect
lordship,
on the society at large.
yes, my last case, my lord, have a look, my lord, page 6, last third case was registered on, my lord, 22/2/2022, my lord.
Hmm.
22, my lord,
So your argument is there is no live nexus between the.
yes, yes,
All right, issue notice to the respondents. MS so and so appears for
All the respondents, lordship.
all the respondents.
And lordship, he is indulging into practices again, lordship.
Arey, why? How do you say so?
Lordship, page 33 report is annexed by the petitioner, lordship. The point number 4, lordship,
33.
page 33.
Pit NDPS Act. then. Pit NDPS, not NDPS. इसमें ही होगा. Right.
After last page. Thirty-three, my lord, summary of all these three cases, my lord.
Oh. Hold on. Where is the order? Order is at page number.
Yes, for a page, my lord, 34, my lord. Starts, my lord. And last bite order 40, my lord, issued by the OC, he was detained, my lord.
Commissioner and Secretary, yes. Notice MS Bhattacharjee appears on behalf of all respondents. Copy of the writ petition be provided to her. Sufficient copies of the writ petition be provided to her. Forthwith, she prays for and is granted. How much time do you need to respond?
Lordship, within 3 weeks, lordship.
3 weeks time to file affidavit in opposition.
Deep problem.
Please stop to 3 weeks. What's there to stay in this order, sir?
Yes.
This order can't be stayed.
Yes, sir.
Why did you make a prayer for stay?
Turn number 17.
Who is appearing? 17. Yes.
My lord, this is an inter-court appeal, my lord. What happened, my lord? The appellant, my lord, he was working as a technical officer in the Institute of Advanced Studies in Science and Technology, my lord. My lord, this institute was run by the state government. Subsequently, it was taken over by the central government. When it was taken over by the central government, the grade pay and pay band both were reduced, my lord. That is the case, my lord. I'm praying for pay protection and pay parity with other employees in other institutes who are discharging similar nature of work and getting a higher pay. So, my lord,
Para
at this-
16 of the order.
my lord,
Para 16 of the order passed by Leonard Single Bench.
yes, my lord. 16, my lord.
Yes.
My lord, this is with regard to pay parity. But there are two aspects, my lord. We would like to press for pay protection, my lord. Para 16 is with regard to pay parity, but pay protection should have been granted, my lord. I understand, my lord, if I cannot be paid equally with those candidates who are appointed by way of regular appointment, direct recruitment. So, my lord, but pay protection should have been there, my lord. Kindly come to page.
All right, we'll put the other side to notice.
Yes, my
Issue
lord.
notice. Who are appearing?
I'm good as 1 and 3, madam.
Mr. So and so appears on behalf of the responsibles 1 and 3. Number 2. For 2. Please record name of learned counsel. 4. Commissioner, Secretary, Department of Finance, Government of Assam. Higher Education, Government of Assam,
Respondent number 5, I think.
5 you are appearing.
Five.
For 5, mark is attendance. Finance, Mr. Nayak. No. Commissioner, Secretary, Department of Finance, Government of Assam. Would you be appearing?
Yes, Lord.
Mr. Nayak puts in appearance on behalf of respondent number 4. Requisites for effecting service on the respondent number 6. 6, no one represents. Be filed within 3 days, whereupon process be issued to such respondent. Sufficient copies of the writ appeal be provided to the council who are already representing the respondents. Rule is made returnable in 4 weeks. You want a dusty service on respondent
Yes,
number
my lord,
6?
dusty, my lord. On
Dusty
respondent
service
six,
is
dusty, my lord.
permitted. Okay.
I'm grateful, my lord.
Letter numbers 18 to 20.
May I please, Your Lordship? My lord, item 18 and 20 are interconnected, arising out of, my lord, the same judgment. So far as, my lord, the 19 is concerned, my lord, this has been listed at the instance of the appellant in item 20, arguing before this honorable court that, my lord, these are identical matters. But that relates to a different Gram Panchayat, my lord. And perhaps, my lord, it is not related, because the issue here in, my lord, is covered by full bench judgment.
Okay.
Yes. Now, my lord, what the honorable single judge says, that the requisition, my lord, which was initiated and, my lord, eventually it led to a no confidence motion against the president. That requisition was not served, my lord, to the president. But eventually, when the matter was taken up to the Anchalik Panchayat level, the notice in that, my lord, meeting, my lord, it was received by the president and he has admitted in the writ petition at para 5. But nonetheless, my lord, I am not on that. Now here, my lord, once the honorable single judge has interfered with, my lord, on the ground of non-furnishing of the requisition, my lord, and thereby relegated the matter back, let the meeting be held within 15 days in terms of the honorable single judge direction.
Okay.
Now, so far as, my lord, the item number 20 is concerned,
So just hold on.
my lord.
So who has stopped the meeting from being held?
My lord, in fact, the
Is there
appellant
a
in
stay?
item 20, he came before this honorable court.
Against that
saying-
direction?
Yes, saying that the second proviso to subsection 5 of 15, my lord, it creates an embargo in respect
No,
of
no
holding a
fresh motion, no fresh motion.
Yes, in fact, my lord, this has been settled by a full bench judgment that unless the, my lord, motion is lost, the embargo will not apply.
Okay,
Now, when the motion is lost, my lord, is discussed by this, my lord, full bench. May I place it, my lord?
right. Is that direction stayed by this court?
In fact, yes, my lord. In the other case, yes. My lord, the honorable court said that the meeting, my lord, shall not be held without leave of the honorable court.
That order is in item number 20.
20, my lord.
Pass. Give that fine.
And I'll make an additional, my lord, ground that so far as the writ appeal is concerned, it is not maintainable in terms of the Guwahati High Court rules, because the rule is very clear. You need to annex all the documents, including the affidavit, opposition and everything. But only the writ petition has been annexed and the order has been obtained, my lord, by suppressing all the facts, which, my lord, was discernible in the affidavit in opposition, my lord. Now, if your lordship comes to paragraph 16 of this full bench judgment, this is a judgment, my lord, by Honorable Justice Salamaster Amitav Roy, NAI Ansari.
Do we need to take names of honorable judges?
I'm just mentioning it, sorry, my lord.
We can read.
My lord,
You can presume.
I'm sorry, my lord. Para 16, my
Yes.
lord. My lord, before that, may I take your
We find
lordship?
it offensive when you take names of judges, please.
I'm sorry, my lord.
It's the
Well,
judgment of this court, a full bench of this court, that's all.
I'm
That
sorry.
should suffice.
I'll learn.
Yes.
Yes. But can I take your lordships to, my lord, second proviso to subsection 5 of section 15, my lord,
Yes,
before
yes.
coming to the judgment?
Sure.
Your lordship will find it, my lord, at the bottom part of section 15. This is the second proviso. Lordship has got it, my lord.
Yes.
Provided further that if it is not possible to hold the meeting for a situation due to non-attendance of the requisite number, the quorum is not, my lord, constituted of the members in such meeting or meetings as the case may be, the no confidence motion shall automatically stand cancelled, and motion shall be deemed to have lost, in the event of which no such motion shall be
It's
allowed
only
within.
if the number of, the attendance is short,
Absolutely,
there's a deeming provision for the motion being lost. And
absolutely.
in that event, the next motion can't be brought before 6 months.
I am obliged, my lord. So what the honorable full bench has held, that if the motion is lost in terms of merit, then only the embargo will apply. But the honorable single judge, my lord, had interfered with on a technical ground. So therefore, my lord,
The motion was never taken to test on its own merits.
absolutely, because the motion was passed by 9 members. So if
It
your
was
lordship comes
passed, in this case, it was passed,
passed,
but then
9 out of 10,
it was interfered on ground of technical ground
technical
that
ground.
the president was not served.
Exactly, my lord.
Hmm.
If your lordship comes to para 16, my lord,
Right.
yes, the second proviso to subsection 1 enjoins that when a no confidence motion is lost, no such motion shall be allowed in the next 6 months. It is the ordainment of section 15(1) that the president or vice president shall be deemed to have vacated his office forthwith when a resolution expressing want of confidence in him is passed by a majority of 2/3 of the total number of members of the Gram Panchayat. It is in the backdrop of this statutorily designed scheme outlining the procedure to process a requisition expressing no confidence against the president and the vice president of the Gram Panchayat that the rival contentions would have to be evaluated. Then if your lordship comes to now, para 19, we may skip, my lord, 17, which is, my lord, not relevant. Para 19, my lord.
Yes.
The meeting dated 12/3/2009, though convened by the Anchalik Panchayat, essentially discussed the issue of no confidence against the president of the Gram Panchayat, and therefore quorum for and the procedure thereof were to be assuredly in terms of section 18 of the Act. Subsection 5 of section 18 mandates that the voting in any meeting of the Gram Panchayat, if required, shall be by raising of hands, except in the meeting where no confidence motion is discussed, where the matter will be decided by secret ballot. Admittedly, in the instant case, secret ballot was not resorted to in the meeting of 12/3/2009 to decide the issue of no confidence against the appellant. On that count, as well as the proceedings of the meeting in this regard, being in contravention of an express legal provision, are liable to be adjudged non-esteemed law. On these 2 counts of visible illegalities, the convention of the meeting dated 12/3/2009, the proceedings thereof, and the resolution of no confidence against the appellant are hereby annulled. So it was annulled on the ground, my lord, that secret ballot was not resorted to. Now 20, my lord, does this determination essentially signifies that the no confidence motion brought against the appellant is lost as is conceived of in the second proviso to section 15(1). The word loss, as has been defined in Black's Law Dictionary, is loss is a generic and relative term. It signifies the act of losing or the thing lost. It is not a word of limited, hard, and fast meaning, and has been held synonymous with or equivalent to damages, deprivation, detriment, injury. It may mean act of losing or the thing lost. The word lost, para 22, the word lost appearing in the second proviso to section 15(1), in deference to the fundamental principles of statutory interpretation, has to be essentially comprehended in the text and the context in which it appears. When so construed and interpreted, it, to start with, seems to signify a rejection of a no confidence motion on merits, following due deliberations in a meeting convened and held in accordance with the procedure prescribed in section 15(1). It cannot be conceived of as an inevitable consequence of any infringement of the prescribed procedural rigor, either by a breach of time frame or unwarranted interference of any authority at any stage of the process or reasons akin thereto. Though such outrages, depending on the nature and the extent of the consequential vitiation, may render the process illegal, the same per se would not imply the loss of the no confidence motion as is contemplated in the second proviso to section 15(1) of the Act. A demonstratively conscious act or omission on the part of those supporting the motion, resulting in the rejection of the motion on merits or testifying the abandonment of the pursuit, would be essential to conclude such a consequence. The bar against the permissibility.
There are only 2 situations as contemplated:
My lord.
rejection of the motion on merits or testifying the abandonment of the pursuit.
Exactly.
Is the motion, it was put to vote, but then it was abandoned,
Abandoned.
or it was lost.
It was
as such
lost.
physically,
In both the cases, my lord, the members do not support the motion
right,
in both the cases.
right.
So therefore, my lord, now
Then
the
the bar of
the
permissibility.
bar against the permissibility of initiation of such a motion within next 6 months after it is lost in the first venture, in our view, opinion is decisively redolent of this view. The quintessence of the proviso, according to us, is to sanction a temporary reprieve to the president or the vice president of the Gram Panchayat in case the no confidence motion brought against him her stands defeated on merit, so as to relieve him her of a fresh ordeal of suffering the same exercise in quick successions. The legislative intent.
This is the most relevant part of it.
Yes, my lord. This is the most relevant part.
Yes. As discernible is carrying.
Yes. The legislative intendment as discernible is thus that a no confidence motion brought against the president or the vice president of the Gram Panchayat is lost within the meaning of second proviso to section 51 of the Act, if either it is rejected on due deliberations in a meeting duly convened as enjoined therein, or if the motion fails for cause or causes other than procedural defects or irregularities in convening the meeting, be it for the violation of the time frame or uncalled for or unauthorized intervention of any authority not contemplated in the scheme statutorily delineated for adherence. Whereas such an infringement of the time schedule prescribed for the successive stages or interferences of authorities not envisaged depending on the extent and the nature of the impairment caused thereby may render an ongoing process vitiated thereby. The inescapable consequence thereof need not necessarily be that the motion would be lost as comprehended in the second proviso to section 15(1) of the Act. Such a consequence is also neither discernible nor deductible from section 15(1). We thus cannot lend our concurrence to the plea that each and every non-compliance of the procedural essentials for prosecuting the process of no confidence motion would inexorably imply that motion of no confidence would be lost. In the facts and circumstances of the case, having regard to the nature of the contraventions, we are of the unhesitant opinion that though the proceedings of the meeting dated 12/3/2009 are valid, in the view of the unauthorized institution of the Anchalik Panchayat in the process, it would not connote that the no confidence motion thereby had been lost so as to attract the bar against initiation of a fresh pursuit with the same objective within 6 months thereof. The process in our view subsists and is capable of being furthered from the stage of the receipt of the requisition dated 19/2/2009 expressing the no confidence against the applicant. So here your lordship will see the honorable single judge, my lord, has held that the meeting was, my lord, rightly taken to the logical conclusion. If your lordship comes to, my lord, page 118, para 10 of the judgment, my lord.
Yes.
There is no dispute to the fact that on 26/9/22, a requisition notice of event date with signatures and seals of 9 numbers of ward members of Anipur Gram Panchayat as requisitionist was delivered to the secretary of Anipur Gram Panchayat, and the respondent 7 had duly acknowledged the receipt of the requisition notice at 3:15 PM on 26/9/22 itself. The endorsement of the respondent 7 on the requisition notice goes to show he received the requisition notice at the office of the Karimganj Jilla Parishad at 3:15 on 26/9/22. There is also no dispute to the fact that the special meeting was convened and held on 17/10/22 at the office of the Anchalik Panchayat. It is also not in dispute that the special meeting held on 17/10/22 was chaired by the president of the Anchalik Panchayat as required by the provisions of section 15(1) of the Assam Panchayat Act 94. Subsection 5 of section 18 of the Assam Panchayat Act 94 has made it mandatory that in a special meeting where a no confidence motion is discussed, the same is to be decided by secret ballots. It is also not in dispute that in the case in hand that the special meeting held on 17/10/22, the process of secret voting was resorted to, and the motion of the no confidence brought against the petitioner as the president of Anipur Gram Panchayat was passed not less than 2/3 of the total number of the ward members of the Anipur Gram Panchayat. So therefore, in terms of the requirement, this was a valid meeting, my lord. Now, what the honorable single judge has said in para, my lord, 17.1, if your lordship comes to page 126, my lord, the third line from the top, my lord, in the factual matrix, your lordship has got it 126, my lord. In the factual matrix obtaining in the case, the onus was on the respondent side to bring cogent materials on record in support of their claim that the requisition notice was brought
to the knowledge of the president in the prescribed manner, rather than the petitioner who has asserted in a negative manner, that is, the requisition notice was never brought to his knowledge in the proper manner. In the light of the discussion above, this court has to observe that the secretary of the Gaon Panchayat did not bring the requisition notice dated 26/9/22 received by him on 26/9/22 to the knowledge of the president of the Gaon Panchayat in the manner required. The one-page note sheet produced by the respondent 7 before this court does not go to show that he had delivered or through whom he had delivered the requisition notice to the president of the Gaon Panchayat. The respondent number 7 has also failed to disclose how the one-page note sheet along with the requisition notice had been received back by him on 26/9/22 or another date thereafter, after the same was allegedly sent to the president of the Gaon Panchayat, that is the petitioner. Para 18, my lord. Having discussed the aspects in relation to both the possible situations, this court is of the considered view that the procedure prescribed by section 15(1) of the Assam Panchayat Act 94 as regards the manner of bringing the requisition notice expressing want of confidence in the petitioner as the president of Anipur Gaon Panchayat within 15 days was not followed in the case in hand. As a consequence, this court holds that the proceedings of the special meeting held in the office of the Anchalik Panchayat on 17/10/22 cannot receive judicial imprimatur. As a consequence, the motion of no confidence passed against the petitioner in the said special meeting is held to be bad in law and the same is set aside. Now, the other part of the, my lord, direction is, your lordship will find at paragraph 21 at page 128, my lord. Taking a cue from the directions made by the division bench of this honor, this court in so and so, this court is of the view that a similar direction is called for in the case in hand, also because the motion of no confidence is not lost. Well, the honorable single judge has said it is not lost, rightly said so, and still survives in view of the fact that it was taken up for consideration in an illegally convened special meeting on 17/10/22. It is therefore directed that the petitioner, as the president of Anipur Gaon Panchayat, shall convene a special meeting within 15 days from today for considering the motion of no confidence brought against him by 9 ward members of Anipur Gaon Panchayat. The petitioner, while convening the special meeting, shall serve requisite notices by mentioning the time, date, and venue of such special meeting in compliance of the aspects prescribed in 17(3) of the Assam Panchayat Act 94 upon all the stakeholders, including the respondents 8 and 16, to attend the special meeting in order to ensure that the proceedings of such special meetings are carried out properly. The Deputy Commissioner, Karimganj, shall depute one gazetted officer not below the rank of Class 1 gazetted officer as an observer for the purpose of special meeting. Then para 22, my lord, as the proceedings of the special meeting has been interfered with, as a corollary, the petitioner is restored to the position of president of Anipur Gaon Panchayat. At the same time, it is observed that until the special meeting to discuss the no confidence motion against the petitioner is held, and that to the no confidence is decided, the petitioner will continue to function as the president of Gaon Panchayat, discharging day-to-day function, but he shall not take any major decision in respect of the financial matter. Now, the other, my lord, writ appeal which has been filed, my lord, without annexing all the affidavit and oppositions as required under the High Court rules, my lord, he had obtained an interim order without placing, my lord, this full bench judgment. My lord, High Court rules makes it very clear. Chapter 5A, it is, my lord, rule 2, my lord, sub-rule 4, in case of writ appeals, along with memorandum of appeal, the certified copy of the judgment, authenticate copy of civil rule writ petition with relevant annexures. In this book, my lord, it is page 57. Copy of affidavit in opposition, counter affidavits, and all other relevant papers filed by the party concerned in the relevant civil rule writ petition from which the writ appeal is arisen must be included. Now, if your lordship sees the writ appeal in, my lord, item 20, only the writ petition has been annexed. Where before the honorable single judge, there was affidavit in opposition, affidavit in reply, everything, my lord. On that count, my lord, that writ appeal, my lord, it goes without being maintainable, my lord. My humble submission, my lord, that the latter part of the, my lord, judgment of the honorable single judge, it does not suffer from infirmity. It is in consonance, my lord, with the full bench judgment. So that may be upheld, my lord, and your lordship may direct, my lord, the president to hold the meeting as, my lord, directed by the honorable single judge. This is my humble submission, my lord.
Yes.
I mean, item number 20, my lord.
What do you say for non-inclusion, non-filing of relevant documents along with the appeal, name of appeal?
My lord.
Why should we dismiss your appeal only on this ground?
My lord, I have only a last observation of the.
Immaterial.
Yes, my lord.
What do the rules say? You are required to file everything. It is the complete record of the writ petition,
my lord.
which you have not done. So your appeal goes only on that ground. He says that that amounts to concealment of fact, and he may be right to that extent. Because had those facts been in knowledge, perhaps we may not have granted you the interim order.
My lord, all the facts, my lordship, in the judgment itself, my lordship, every fact has been.
There are so
stated,
many
my-
things which are said in the pleadings.
Yes, my lord. And
So your appeal is
I have,
on that count. All right, forget about that. What about this full bench judgment? What do you say about that? If perhaps you are not even aware of it. Or you are. The motion must be tested on merits. That is what the sum and substance of this judgment is. It can't be thrown out on technical grounds. That is what the sum and substance of this judgment is. Let the democratic
my lord.
process be taken to its logical conclusion.
my lord, my only plea was that, my lordship, under section 15, my lordship, section 16, my lord. The requisition notice to the.
It was not served on you, all right. So that is a
technical.
technical defeat given to the notice because you took a plea that the notice was not served.
Yes,
No, all right, let us put you to notice, get the motion tested again,
my lord.
gain the confidence of the members, continue to hold the post. That is what the sum and substance
My lord.
of the full bench
Ultimately,
judgment
if
is.
The motion is, if the motion is not lost, my lordship, they are at liberty to give requisition notice, my lordship. Because.
The
this
requisition notice, now you have the knowledge, sir. Now that is what the court says. Now the onus is put on you to convene the meeting.
No, the meeting which I have challenged, that was convened by the Anchalik Panchayat, my lordship.
So that is a technical ground on which the meeting was struck down, sir. That is what the argument is. What comment do you have to make on the full court judgment? How do you get out of the rigor of the judgment? Let's know that.
My lordship, I want only one day,
No, sir.
only one day. So
A
that,
big
I-
no. In capital letters. Having argued the matter, having sat through the arguments for 15 minutes.
Yeah.
Absolutely no.
Actually, presence of Anchalik Panchayat is also required. The honorable court directed for taking Dasti service also, my lordship. So
They will
Dasti
come, don't worry.
service-
They will come. They will come in the meeting. Yes, anything else to say?
My lord, I filed the writ appeal only on two grounds, my lord.
Yes,
Only
your
one
writ
ground.
appeal is liable to be dismissed because you didn't file the documents. We'll vacate your stay on this ground. Okay. In your appeal, all respondents are served.
My lord,
Sure.
my lord, in fact, Anchalik Panchayat is not served, but Anchalik Panchayat now, my lord, will be, my lord, since the, my lord, it will be held at the Gaon Panchayat level, well, it's not, it will be only a formal party, my lord. It will not be agreed also, my lord.
Okay. All right, arguments heard. Order reserved in both of these appeals. Give a
Deeply
brief synopsis of arguments, please.
My lord, deeply obliged.
What about item number 20? This 19? Masuma Khatun, who is appearing in that?
In appeal, I am appearing in, they have filed an application for vacating the interim order.
Yes.
Last occasion, they were absent and it was deferred.
What is the interim order passed by this court?
My lord,
What is the direction of the Leonard single bench?
page 62. 61, it starts on paragraph 7. Here also, my lord, the requisition notice was
Not served.
not served up, it was served up, my lord, it was addressed to the, my lord, Anchalik Panchayat BDO.
So same situation,
Situation
yes,
is exactly same, but one question, my lord, your lordships may consider here in this. case,
yes.
That, my lord, we are ready to, my lord, convene the meeting because I'm president. It is a democratic. My lord, only question is that only section 15 may be followed. They may file a fresh requisition.
Why?
We
Why?
are
The
ready to-
requisition has not been lost. That is what the
No,
full
not
bench
lost,
shows.
But
Says,
it was, my lord, served to the video. It was not,
now you have ample information.
Yes, and the only purpose is well, information.
information. That is correct,
Whether
but
she
it
has
is not
the-
served to me.
Whether the party has the info. Sufficient.
Now you have the information.
Now,
Yes,
my
yes,
lord,
now it, I
do
have.
So your case also goes on the same,
yes.
same direction.
My lord, Footing is same footing. Now only my prayer was in single bench.
You can go out gracefully saying that yes, petitioner herself will ensure, appellant herself will ensure that the meeting is held.
No, meeting was held, resolution was taken also. my lord. That
Yes,
was-
a fresh meeting will be held.
Yes, fresh meeting. I am ready to convene.
Then what is
Now
the
only
fun in?
under section 15, maybe.
No,
followed
no
by the-
fresh requisition is
Fresh
required.
There is a
That is
settled law, no, nobody can.
That's what the full courts, full bench
Yes.
says.
No, in full course.
Full bench doesn't say that a fresh meeting would require to be convened.
Yeah.
That motion is not lost, so it still survives.
That is correct in case of, my lord, that section. But here, my lord, the requisition notice was not served, even video it was served.
That's
I
what
have
the
knowledge,
exact.
now I have
Obsolete
knowledge, it is correct. my lord.
So then,
That is-
so do you want a graceful withdrawal or an order on merits?
My lord, That's the. On my lord, I have to convene, my lord, that is.
So
will-
you want an order on merits?
Mer-
We'll
because-
pass.
because-
All right,
If without instruction of my kind, I cannot withdraw.
dismissed. Very well.
Obliged.
Yeah, that full court judgment, full bench judgment will. dictate it.
I hate to be a mother, let me see what application that is, 19 of November.
Item number 22.
Date has been given in 22, must be 21. 21. In 20. date-
22, my lord, item number 22, a period of 10 days to file my affidavit, my lord. Notice was not issued in this matter. I have
22,
some instructions.
This
but,
so and so submits that he needs, he may be granted, Mr. Mazumdar.
Mazumdar, my lord.
But you were there on the last date, 31st.
Yes, my lord,
March.
I have got the, some of
Mr.
the
Mazumdar
instructions.
states that he has received instructions and would be filing the affidavit within next
10 days, I'll file. it.
10 days.
My lord, some urgencies on our part, my lord. I pray for a date,
Earlier
my
than
lord.
that.
Let's start 15th May.
Obliged.
Obliged, my lord.
Item number 23.
Yes.
My lord, some developments have taken place, my lord. On the requisition submitted by the petitioner, my lord, the response number 3, the branch manager sent a letter, my lord, to the petitioner, which she received on day before yesterday, my lord.
Mm.
And he asked her to come to the, my lord, branch office to settle the matter, my lord.
So what do you want now? Otherwise, your rate is not maintainable. See the judgment. Supreme Court judgment. Where is that judgment? Council has taken it away. It's here. Read this latest judgment. Supreme Court has come down heavily on the high courts who are still entertaining these writ petitions.
My lord, now they will settle the matter, my
So
lord.
all right, you withdraw your writ petition. Your rate is otherwise not maintainable. Otherwise, we'll be compelled to dismiss it on ground of.
Mm.
So what do you want? Withdrawal
My lord.
in Land Council, MS. Takuria frankly concedes that in view of the judgment rendered by Honorable Supreme Court in the case of so and so, the appropriate remedy for the petitioner would be to either approach the bank officials for settlement or to approach the DRT
No,
against
my
the
lord, she will, my lord, go to the, my lord, office of, to
bank
settle the
officials
matter.
or to avail other suitable remedy as provided in law. She craves liberty to withdraw the writ petition, hence the same is disposed of as withdrawn.
Obliged, my lord.
Item number 24.
Lordship, item number 24, Lordship, I need 10 days time more, Lordship.
10
File an
days.
affidavit, Lordship, actually what has happened, the concerned person is based in Faisal. And she is a lady, her daughter is having dengue for last 2 weeks. She has sent me the huge bulk of materials, but a lot of materials are there in vernacular medium, so I could not make out anything. So 10 days time, Lordship will kindly permit me, I'll file an affidavit. Lordship.
Mr. Kalita submits that he has, Additional Auditor General Mizoram submits that he has received a bulk of documents, but requires some time and proper assistance to file the affidavit in opposition, affidavit on behalf of the state of Mizoram.
Obliged.
The appellant's counsel Chaudhary does not object.
I'm not appellant, my lord.
You are-
I'm the
Uh,
petitioner, private respondent.
Okay,
Appellant by Union of India.
Okay, the learned counsel for the Union of India does not object to the submission so made. List after 4 weeks,
Three
the
weeks.
affidavit be 3 weeks.
3 weeks.
The affidavit be filed in the meantime.
Lordship.
Okay.
The number 25,
May I please your lordships? This case relates to selection and appointment of the post of Gaugura. Initially, the post was fell vacant in the year 2012. Respondent number 1 was appointed without following the due procedure of law. Then it was challenged before the commissioner and say accordingly appeal appointment was set aside. Subsequently, respondent wants setting aside his appointment before this honorable court with a writ petition, and this honorable court in the earlier proceeding directed the authority to initiate a fresh process of selection on the basis of new qualifications. Your lordship will find page 21. Page 21, there is a notification 5/1/2016, page 21.
Yes. Yes, notification, yes.
Yes, page 21, lordship column 2, inserted educational qualification for the post of appointment to a matriculate. In the original executive instruction, that is Assam Land Revenue Regulation 8086, there is no qualification regarding the post of Gaugura. And that by notification, it was inserted matriculation is required. In the Eastern case, by WT message 20/2/17, that notification withdrawn, page 29.
Yes.
Page 29. May I read, lordships? Dated this food, the 20th February 2017, kindly refer to government notification number so and so dated.
Yes, it has been
6/1/2016.
withdrawn.
Withdrawn.
Then what?
And not to act, not only withdrawn, not to act on this notification. Thereafter, advertisement was issued. On 31/11/2017, advertisement issued for filling up the post of Gaugura. Initial advertisement, no persons applied. Then initial advertisement abandoned, the second advertisement was issued. That is page 30. Against this advertisement, that is dated 29/12/2018. 6 candidates applied. In the notification, there is no qualification has been mentioned. Part of the qualification for the post of Gaugura. In
Page
the
31.
advertisement also.
Column number 5, page
Yes.
number 31.
Yes. Additional qualification of the applicant, nothing else mentioned. So meaning thereby, executive instructions has to be followed. It was that earlier inserted in the notification dated 6/1/2016, that was kept in abeyance and even directed the authority not to act on that notification. Then thereafter, the selection authority conducted selection on 3/4/2018, that is page 33. I have been selected on merit. My name appears serial number 2, appellant, Nurul Amin,
You
got
got-
March 68. And serial number 3, respondent number 1, Kasim Ali Ahmed got 63. On the basis of selection, I have been appointed to charge number 17. And accordingly, I joined on 13, 4th and 18. Respondent number 1 challenged my appointment, stating that matriculation is required on the basis of initial notification dated. But here he has not either challenged the notification, subsequent notification regarding withdrawal of the earlier one, and even the advertisement also. Learned single judge and your lordship, thereafter page 34, that notification came into force. Selection conducted 3, 4th and 18. And I have been appointed 12, 4th and 18.
12/4.
12, 4th and 18.
So this notification. is just-
Yes, that notification came into some effect lordship page 34 on 23/2014.
23rd April, yes.
Yes.
All right.
So during prior to that, selection has been completed. On the basis of executive instruction, since there is no requirement of qualification for the post of Gabura, authority rightly appointed. My respondent 1 challenged my appointment, stating that matriculation is required. Learned single judge hold that although the notification has been kept in abeyance, but it was not cancelled. So it was remained stayed. On that basis, the writ petition was allowed. My appointment has been set aside. Your lordship, paragraph 13 of the learned single judge judgment, I read. Page 39 is the judgment started.
Yes.
Paragraph 13, 14, 15.
Yes, yes.
Yes, lordship. Lordship got it, page 48, paragraph number 13.
He was not disqualified on the ground that Yes, please. What do you say?
Yes.
Keeping in abeyance has the same effect. He was not disqualified on the ground of not having the requisite educational qualifications.
In fact, your lordship, if your lordship can kindly come to page 49 for a moment, your lordship. Page
Yes.
49, which is the impugned order.
Mm,
Page 49.
mm.
Paragraph number 14, your lordship. The entire set of facts, your lordship, if I may be permitted to read, your lordship.
Whatever, just hold on, hold on, hold on. For a second, just hold on. Can you call some medical facility, please? Immediately. Is this working? Rupam may be called. Let her have some air, fresh air, please. Is the doctor in the premises? Call him fast, quickly.
The doctor stays in an old building.
They sent a message. Does she have any history or what? Painting? We don't know. Try rubbing her feet. Madam. Rub her feet vigorously. That would revive her quickly. Could have asked the doctor to rush.
Gaining her sense now.
She's in her senses, but. Give her toffee to chew. Maybe, it may be hypoglycemic kind of thing. Is she diabetic? Then this is a bout of hypoglycemia. Give her a chocolate in the mouth. No? We don't know. Maybe she can chew the toffee. Yes, the medical. We can rise for a few minutes and the others can go out. We'll request the other councils to please move out. We'll also rise for 5 minutes. Let her have the attention. We'll come back after 5 minutes. Yes.
Your lordship will kindly come to page 27. In paragraph number 5, your lordship.
Yes.
I'll continue from the 7th line, your lordship. This is considered necessary as fresh eligibility norms are prescribed recently to ensure.
Now
appointment-
that was educational qualification.
Yes, now that is what has happened, your lordship, when your lordship has referred to fresh eligibility norms. Notification 5/1/2016 has been referred here.
6/1/16.
6/1/16, your lordship. However, your lordship, this order was passed on 31/5/2017, whereas that notification, your lordship, was kept in abeyance from the 20th of February 2017.
Maybe that was not brought to the notice of the
That was
court.
not brought to the-
So
Thereafter, your lordship, this honorable court had directed that the selection process held as per the fresh eligibility norms. The fresh eligibility norms were not there. It was it was in suspension at that point in time, your lordship. Thereafter, the selection had taken place and the appellant, your lordship, was selected.
right.
We chose to assail the selection process before this honorable court, your lordship.
And the learned single judge says that keeping in abeyance doesn't mean that the norms have been cancelled. Then what is the meaning of keeping in abeyance? If you apply it
Yes.
while they are in abeyance, what is the sense?
Yes, in fact, your lordship would see.
If
entire set of facts-
if the norms were still in force, he should not have been allowed to apply because he was not qualified. He could not have participated.
Yes.
The authorities would have restrained him.
Yes.
So why the court is supposed to say that it was in abeyance, but still it was being continued? It's a self-contradictory finding.
Yes, in fact, if your lordship will kindly come to paragraph 14, your lordship.
Yes.
Paragraph. Page 13, paragraph 14, your lordship, is at page 49, your lordship.
Yes.
By the notification bearing so and so dated so and so, the state government amended the existing executive instruction 160 to executive instruction 167 contained in the regulation 1886. These instructions inter alia provided for the minimum qualifications, duties and
Sir,
responsibilities.
what is the meaning of not to act on the notification?
Yes.
Simple. Dictionary meaning not to act upon it.
Not to act upon is to abstain from acting on that.
So then-
What has ideally should have happened, your lordship, with my humble submission, was the fact that the notification not being in force should have ideally been brought to the notice of the honorable court by way of a review or an appeal. That was not done. That was not
Is
done.
immaterial. He has applied against the situation of election as it prevailed when the notification, when the election process was held.
Yes,
Under that, he has not been disqualified.
yes.
That means he is qualified. The state says he is qualified and he has secured the highest number of marks. Where is the question of interfering?
In fact, when the notifications had come into force, thereafter that notification, after being kept in abeyance, was further improved.
Maybe,
further
maybe,
improved,
but in the intervening period, he was elected. So his election can't be set aside by that manner. Admit and stay. Admit, stay.
Obliged.
Yes. Okay. Yes.
Matter
If
number
your
two-
order is so and so shall remain state, effect and operation. We'll elaborate. Yes.
Matter number 26.
Please, your lordship. But the issue before your lordship my lord, is the recovery of the excess salary paid to the employee, my lord. What had happened, my lord, the predecessor in interest of the respondents herein, my lord, who were the petitioners. My lord, he was appointed as a lineman, my lord. He was working as a lineman, my lord. His date of birth as recorded in the service book was 31/12/1952, my lord. Now, inadvertently, my lord, there was an error in copying that in the superannuation register. So no notice was sent to him, intimating him about the date of retirement, my lord. As
And
a
he
result,
continued.
he overstayed. So then he passed away when the pension papers were processed, my lord. This came to our notice, my lord. Accordingly, we recovered, my lord. And that has been interfered with by the honorable single judgment
Right.
and imposing a cost of rupees 10,000, my lord.
You are serious about the cost or the recovery?
We're serious about the recovery because, my lord, it was a mistake on our part.
Yes, so.
But the service book, my submission is very limited. The service book is well within his knowledge, man, because it is annexed in the writ petition. It is not their case that they did not know about the date of birth. So what I am on, my lord, is two things.
So
my
the
lord.
person who was to explain is no more.
That is true, my lord. Lordship is absolutely, I'm with your lordship on that, my lord. But the thing is that the obligation of the employee is also there. I'll be relying on a government of India order, my lord.
Continue to offer his services.
That is there. That is there, my lord. Only one judgment, if your lordship permits me, my lord.
Sure, please.
1997, my lord, 9 SCC 239, my lord.
Yes.
It's a very small judgment, my lord. 2 pages. I have one copy, my lord.
Don't bother. Pass on the copy.
Page number 239. My lord,
Yes.
in my respectful submission, my lord, the judgments relied upon by the honorable single judge, my lord, is on a different footing, my lord. Because the case of Rafiq Maji, lordship knows, it was a case where extra payment was made because of a wrong fixation. And in the other case, which has been relied upon, my lord, in that case, my lord, admittedly, there were 2 dates of birth in the service book. A subsequent date was relied upon, and he continued to serve, my lord. Under those circumstances, that judgment was passed. The short judgment, may I read, my lord? This is an astonishing and more shocking case. The petitioner, who was admittedly to retire on 31/5/1991, remained in office till 31/5/1994 as if he was not to retire from service, enjoying all the benefits of service. This special leave petition arises from the order of the Central Administrative Tribunal, Patna, made on so-and-so, in OS so-and-so. The petitioner had joined the Service and Telecommunications Department. Admittedly, his date of birth is 13/5/1933. On attaining the age of superannuation, he was to retire on 31/5/1991. Instead, he remained in service till 31/5/1994. When action was taken to recover the amounts paid to him for the period beyond the date he was to retire, namely so-and-so, and to which he was not entitled, he filed OA in the tribunal and the same has been dismissed. Thus, this special leave petition. The learned counsel for the petitioner contends that since the petitioner has worked during the period, he is entitled to the payment of the pay and allowances from 1/6/91 to 26/6/94, and that he is also entitled to the payment of provisional.
This is a case of the petitioner demanding payment. This is a case of recovery.
Recovery. Here also it was a case of recovery, my lord.
No, herein it is not a case of recovery.
It was
Herein
not.
it is, you withheld the salary. The employer withheld the salary in Radhakrishnan.
No, my lord, he worked because he worked
He
in
worked,
1994.
but the payment was not made. He
Here
made a
also,
claim
madam,
for salary.
Here also we
So
are
there is a
recovering-
distinction, a recovery and demand for payment towards overstay.
My lord will kindly read a little bit further, my lord.
Sure, sure.
My lord. Paragraph 3, my lord. Under so-and-so, on the plea that he retired from service, we are aghast to notice the boldness with which it is claimed that he is entitled to claim all the benefits with effect from the above.
Claim everything.
My lord.
So this is not a case here. Here you already paid and you want to recover.
Lordship, we kindly come to paragraph 4, my lord.
Yes.
It is then contended that the petitioner would have conveniently secured gainful employed elsewhere and having worked, he cannot be denied of the legitimate salary to which he is entitled. Though the argument is alluring, We cannot accept the contention and given legitimacy to illegal action taken by the authorities. If the contention is given acceptance, it would be a field day for manipulation with impunity, and one would get away on the plea of equity and misplaced sympathy. It cannot be and should not be given countenance, my lord. And also the last paragraph of paragraph 3, my lord. It is not the case that he was re-employed in the public interest after attaining superannuation. Here also is the same case, my lord. Under these circumstances, we do not find any illegality in the action taken by the authorities in refusing to grant the benefits. Lordship is correct, ma'am.
There is a difference.
There is a difference.
Here it is it's a case of recovery. And the man has passed away.
Man has passed away.
Now you are trying to recover from the retirement benefits.
Retired benefit.
Bring a judgment on that aspect.
That aspect on direct judgments we have not found, my lord, because
Not be able to, you'll not be able to.
because and another notification, my lord, of the government of India, my lord.
Yes.
I could not lay my hands on the notification, man. It's the notification of 1965, my lord.
What does that
May I
say?
hand over the book, my lord?
Sure.
I have highlighted the portion.
How is the employee supposed to retire without the papers being drawn? There is a process of drawing the retirement papers, the
Correct.
GPF,
Correct.
this, that, the N number of formalities, no
There are-
dues. So unless you give him the intimation that you are retiring on such and such date, when he will process the document?
But he is also aware of the date, my lord.
Maybe you are, but you have recorded it, otherwise
Because
he's a
the
class
second-
4 employee.
No, the second paragraph, my lordship, my lord, at the same time, a government servant cannot take advantage, my lord. That part.
Non-receipt of formal order is different. You record a different age. He says that all right, you may have amended.
No, my
For
lord.
all we know.
His case is, he does not know, my lord, because that is in a separate register, not in the service book.
Right.
Service book date is admitted. He knows it is 31/12/1952, my lord. If I may show that particular page, my lord, of the service book. Page 48, my lord. 48 and 49. This is part of the writ petition, my lord. It was annexed with the
There
writ.
is another question.
Hello.
What is the permissibility to effect recovery from retirement benefits? There will be a distinct set of rules for that. Gratuity. Read the Gratuity Act.
My
What
lord.
kind of recovery can be effected?
Normally,
from that?
gratuity, my lord, it is only if it is financial loss is caused,
Yes,
not
so
otherwise.
that's not the case.
That's not.
Because he has worked,
He has worked.
then again, had he been still in service, maybe you would be entitled to effect recoveries, but that would not arise because it's a case of overstay.
Overstay.
So there are, maybe we'll admit it for academic purposes, but will not stay.
Then lordship will at least observe that it will be subject to the outcome of the writ petition appeal.
That we can, what do you say, sir?
Lord, my responsible submission would be the order that has been rendered by the learned single judge is very region 1. A class 4 employee, that to a lineman who remains outside all the time.
He knows his date of birth, sir.
I know my date of birth, but then my lordship will kindly appreciate the practical aspect. A person having given the date of birth to them, it is for the office to maintain, and they intimate at the time when retirement is due. The rule requires that an intimation comes, and accordingly other processes.
That's what we are saying, sir.
Yet the
We'll just,
person was lying ill.
we'll just admit the appeal, observe that
That will,
whatever
my lord,
payment
again,
has been made without passing any stay in their favor.
My lord, that will happen. What is my concern is the family is in penury. If the wife.
We are
suffered
not
from
permitting them to effect recovery.
They have already done. Now they have to return it.
It has already been done.
They have already recovered.
They have recovered.
Yes. That is how the letter single judge has said that no, you return it.
Then
with
there is no
interest.
case for admissions.
With interest, you return it at cost. So you have come here. And well, here, as I find, this is only to satisfy their ego, I suppose. The authority ought not to have in such cases gone ahead with the appeal. They should have.
At best,
Certain portion is recovered, but a certain portion is yet to be recovered.
at best, we can give you relief to the extent of cost. not beyond that.
My lord, in my respectful submission, even they should be imposed further cost. Because they kindly see the situation of the family.
Not a case of cost, sir.
My lord, here.
It's an error purely
Not-
because of human error.
My lord,
The authorities, the officers, if they did not take this action, they'll be hauled up by their audit department.
my lord, they now want to throw the blame on me, that it was
No,
my
no.
turn. That is how kindly see the temperament.
See, sir, if they didn't take this action, their audit department would have effected recoveries from the officers
My
concerned.
lord, if
That is the
someone
consequence.
responsible for that, I think that should happen.
That's true, that should
That
happen, yes. But we don't know who the officers were at that point
It
of
is for
time.
them, it is for them to find
So
out.
the present set of officers, they would be held liable by the
My lord,
auditors.
my
They
lord,
don't look.
If they were not the persons at the relevant time, they will escape. But I
No,
don't
they
think-
will not escape.
But the thing
See-
is, my lord, and the thing is, a person should not be subjected to such arbitrary treatment. And that to a person of this nature, who was
This-
suffering and lying in bed.
We'll
for
dispose
years
it off,
together.
we'll make the cost easy. We'll
I'll leave it to your
the
lordship.
cost.
Some amount lordship will can be retained.
It's not a case of cost, sir. Not a case of for imposing cost. In that event, all right, we'll admit,
I'll leave it
the
to your
prayer for
lordship.
interim relief
But then-
declined.
but then my responsible submission.
Then the petition is appeal is admitted, prayer for interim relief declined. All right, except for,
Well, then
payment
that
of
will be a-
cost.
That will be a plea for delaying the whole thing. I will be suffering.
so then,
So,
let the cost be made easy, remaining part, we'll affirm the judgment. Extra cost not justified. It was a
cost
genuine-
is removed, my lord. Cost part will go.
Yeah, cost part will go.
Other, this will
That-
comply.
This is a genuine legal argument which they have raised. It's not that they have just come on their whims. It's a legal step which they have taken. They think that the recovery could have been or should have been effected. So what is wrong in that?
My lord, I will not go to further, but then here is a case lordship has seen how they have dealt with.
Sir, strictly speaking, this judgment, there can be an interpretation that no such amount could not have been paid and so it should be recovered. Read this judgment, please. There is this
No, my lord.
possible view.
My lord, there are pattern of decisions subsequently that
Rafiq Masi would not apply,
the
sir.
Rafiq Masi also says.
Rafiq
other
Masi, that is a
judgments are
case-
also there,
That
that
is
the
a case
apex
of
court has said.
wrong pay scale.
Thomas
This is not a
Dekel
pace, not a case of pay scale, sir.
No. my
It's a
lord,
case
here
of
it is not.
overstaying.
Yes, my lord, here, at any rate, my lord,
All right, then, sir, if required, so many arguments, admit. Prayer for interim relief
no, my
declined.
lord, I am not going on to lordship asked me, that's why I am saying. Otherwise, it will cause hardship to the family, my lord.
So then, all right, feel happy with what you are getting.
Yes, my lord, that is
Dismiss
what I am
cost,
saying.
cost aside.
Oblige.
Matter number 27.
Please, your lordship,
Yes.
my lord, this writ petition was filed challenging the virus of 43D5. And my lord, we have served the copies them on before the matter was listed.
Mm.
And your lordship can kindly see the order of 3rd March 2023. And your lordship, there was a brief hearing in this matter. And your lordship had the view that perhaps this proviso, the section 43D5 may be read down. Now, what happened, your lordship? They were supposed to file their counter. Now what? Yesterday, I had some hunch feeling. I called up the deputy SDI. He was saying that Siddharth, it is parties are not properly made. So what is the parties properly made? It's the same issue like JNK, my lord, that your NHIDCL matter. If your lordship kindly see the cost title, the Union of India was been represented by Cabinet Secretary, my lord. That is, then as far as second respondent is concerned, the Union of India to the Secretariat, it should be Secretary and Ministry of
Secretary.
Home Affairs. And the third is fine, my lord, is
Law and Justice.
Ministry of Law and Justice.
So only regarding number 2, it should be secretary.
Secretary and that one, my lord.
Do you stand on these ceremonies, madam?
My lord, in this case, Deputy Solicitor General APR, my lord, we have to file that.
So you were given almost a month, more than 1.5 months have passed.
My lord, last chance may be given, my lord, we'll file our affidavit.
Learned Counsel, Mr. Burgoyne is permitted to make necessary corrections in the cause title to the extent of description of the respondent number 2 in the memo of parties.
2 and 3, madam, minister is there, ministry.
Ministry, okay, 2 and 3. MS so submits that one more opportunity of 2 weeks may be given
My lord,
to
4 weeks, my lord.
4.
My lord,
It
what
will
is the
take some
problem
time,
is
my
what,
lord.
my lord, what the problem is why?
Hmm.
Your lordship, there are batches of criminal, batches of trials are going in the special court NIA. And to be very honest, your lordship, it can be verified also. These are basically technical evidences like from the call data and all. Those have been, my lord, coming down, means that getting diluted. And we cannot file the bail application because of the rider of 43D5. And these people are behind almost for 6 years, 7 years.
All right, so 4 weeks further would not make much difference. See, place for is granted. Last opportunity of 4 weeks to file the counter.
Can you correct it by hand, my lord?
Correction permitted by hand in the court.
My lord. Hello.
Number 28.
Why don't you file a fresh cause title? That will be better.
Pardon, my lord?
You file a fresh cause title right now, amended cause title.
My lord.
It's permitted to file an amended cause title with necessary corrections in the description of respondents numbers 2 and 3.
My lord.
May I please your lordship, my lord, in this case, my lord, Mr. A.R. Bhuya is appearing, my lord, having a news that his one of close relative has expired not just a moment ago, my lord, he hurriedly left the court, my lord. So, my
Who?
Mr. A.R. Bhuya, Learned Counsel, my lord.
It stated that Mr. Arguing counsel, Mr. Boyan has suffered some bereavement and a prayer is made to adjourn the matter list after 2 weeks.
Number 36 of supplementary.
Lordship, in this case, senior counsel from Delhi is appearing online.
Yes.
I hear, my lord.
Yes, yes.
The lordship said given liberty to my friend to file an affidavit. He has been served an advance copy, my lord. I don't know if your lordships have received it.
No, it's not come on record. You
My
filed
lord,
the affidavit?
My lord, apology with folded hands, my lord. The system of signing it digitally, it's not available in the University Grants Commission office.
You need to take assistance of Learned Advocate General. State is proceeding fast.
My lord, in there, my lord, intra office, they can do it, but when the document, they have to sign and send it to a surface, it's not there. So, my lord, my respectful submission, they have sent this, signed that scan copy they sent to me and ready with the filing. I'm keeping with me and I have served a copy with my friend.
That Mr. Nair says that you have provided him a copy.
I have provided, my lord.
So when will you be able to file the affidavit now?
My lord, if lordship fix it after 6th of May, my lord, I'll do it, because from 2nd to 6th, I'm out of town, my lord.
Mr. Nair, what to
Very
do?
well, my lordship, I have it on the 8th if it's convenient to your lordship.
8, Mr. Chamba submits that he has received the electronic copy, soft copy of the affidavit, but needs the presence of the officer to file the same on record. List on 8th May as per it.
8th of May.
8.
Number 37 and 38.
Yes.
My lord, can it be on 9th or 10th, because 7th is Sunday.
Then council has left the meeting.
No, my lord, my friend is there, my lord, he will inform.
Indicate-
Again, I will have to take the instruction, Lordship.
Ask Mr. Nair. He otherwise appears through VC. What is the difficulty for him?
Because 7th is Sunday, my lord, that is fine.
9th or 10th, whatever you ask the council and let the court master know.
know.
Yes, please.
10th could be, huh?
My lord, 38, my lord, this is analogous appeal, my lord, arising from the same judgment. Only, my lord, there was a delay of 111 days. In earlier occasion, they took time for filing objection 2 times also. My lord, I pray that this may be.
37, first we have taken up 37.
38, my lord.
38. There is a delay.
37 also, I am respondent number 13, my lord.
You
I
are
am supporting the, my lord, appellant.
supporting the.
Yes, my lord.
May to your lordship.
Yes.
Lordship, in the IA, my lord, we have filed an affidavit. Department has filed an affidavit, my lord. Lordship may kindly have a look. Page 7.
Who represents the appellants in item number 37? Mr. Chaudhary was there.
37 Lordship, Mr. Kane Chaudhary, Senior Counsel will be appearing, Lordship.
So where is he?
The Lordship, he is on leg in another court, Lordship. In this case, Lordship, we have filed an IA in which for stay of the order. And
There is a stay passed in your favor on 30th March.
Lordship.
They have filed an affidavit in opposition.
Lordship, 2 oppositions have been filed, Lordship.
Then
So, Lordship, can this matter be taken up for admission hearing on any other day, Lordship?
what do you say?
My lordship may kindly have a look. My affidavit for a moment. Page 71, my lord.
Yes.
Paragraph 5. May I read, my lord?
Yes, yes.
That the deponent begs to state that out of the total 39 numbers of sanctioned posts in the cadre of district transport officers, there are 17 numbers of posts lying vacant. The deponent further begs to state that out of the 17 numbers.
7 days, heavens are not going to fall. Wait for 7 days more.
My lord,
List the interlocutory application and the connected writ appeal on 4th May or 8th May. Interim order shall continue till next date. And then what do you say in 38 about delay condonation?
lordship, there is no interim order, my lord.
There is an interim order in 37.
37 is as part of your statement that you have said that they will not.
Process, no promise, the undertaking given.
Undertaking has been
on-
given by the state.
On 30th March shall. The undertaking given on 30th
yes.
March shall continue, shall remain in force.
Lordship, can it be on the 10th, Lordship?
10th,
10th of May, Lordship.
10th. And what about the delay condonation in item number 38?
Supposed to file the objection, but they have not filed.
This appeal is delayed by how many days? Connected writ appeal.
11 days, my lord.
Connected writ appeal has already been numbered. The respondents' counsel have not objected to the prayer for condonation of delay. Hence, the application is allowed and the delay is condoned. The registry shall number the connected writ appeal and list the same for admission on 10th May.
Along
With
with
the connected matter.
along with this.
One thing
Along with
pointed out, the appellant also, my lord, he is also in the zone of consideration for promotion.
Yes, that is.
Copy of the writ appeal be provided to the learned counsel representing the respondents.
Master.
10 people.
Number 39.
I have to clarify whether there was any contempt or not, lordship. That was the issue. That order was passed on 24/2/2023.
Regarding?
And the order is that balancing the equities, it is directed that till the next date, that is 13/3/2023, no coercive action of any measures connected with the additional performance security be taken against the petitioner. That was the order. In that case, lordship, there was a.
You are referring to order dated?
Order dated 24/2/2023 in page 56.
56. Yes.
In page 57, that part is in the third from below.
Yes, yes.
In this case, there was a representation on 22nd where they prayed that their representation should be considered. And in the meantime, on 7th of that month, lordship, 4 petitions were dismissed. This representation came on 22nd, and there was some miscommunication about this order with our standing counsel and the department, lordship. So when it was pointed out to them immediately, lordship, on 10th of March, the case was next fixed on 13th. 10th of March, we have informed, lordship will kindly see the reference. I have just submitted this letter.
Yes.
Application number so and so, case number 1052, that is the order, lordship. Here we are in continuation of the above letters. This is to inform you that the bid security of Rana Construction was forfeited on 28 February 2023 as per the Honorable Guwahati High Court's order and judgment dated 7/2/2023. That was the first batch of cases. And the amount is kept in the Assam State Road Board bank account. This was done before we received the intimation of appeal made by Rana Construction dated 3/3/2023. further, these 4 packages were retendered, dated so and so with bid submission date from 8 March to 21st March. However, the bid opening process will not be carried out until further directions from the Honorable Court is received. All this information regarding the violation was immediately informed to the Honorable Court on 13th. The Honorable Court took cognizance, but it was not reflected in the order. And their counsel, senior counsel K. N. Chudir also was satisfied that we are already taking action to rectify our mistake.
Okay,
And subsequently that all the petition was withdrawn by them also.
all right.
Then there are the 2 further round of litigations took place, Lord.
Mhm.
And this is still continuing. The work is still not been, the retender process has not been processed any
Not
further.
processed. So now what is their grievance in this writ appeal?
My lord, readable is that, my lord, they had, since they had already issued a retender, my lord.
Right,
Retender, they had a work, my lord. A petition was there, my lord, they may proceed with the retender, my lord, ultimately petitioner will be deprived, my lord. That is the, my lord.
so now what is your petition about? What is your appeal about?
My lord, appeal about, my lord, not protecting the, my intent prayer, my lord. My
Not
intent prayer met in the petition, my lord.
non-compliance of the direction,
No, my lord.
then
Not accepting my prayer, interim prayer, my lord. That,
in the writ
my
petition,
lord, my lord.
what is your interim prayer?
That the petition, my lord, the interim prayer was the, my lord, pending the rule, my lord, the NIT should not be affected, my lord. The NIT tender, my lord,
Yes,
that should not be given effect, my lord. That is, the-
so you want the retender process to be stopped,
My-
on what ground?
my lord, my lord.
What
See-
ground?
Since, my lord, that was done, my lord, during the, my lord, continuation of an interim order, my lord.
Interim stay in your favor,
My lord.
okay. And let's read, all right. What is the order passed by Leonard Single Bench,
My lord,
which you have challenged?
that already, page 57, my lord, that was the order, my lord.
24th February, that is the order.
My lord.
105.
And the last order, my lord, 24 to then 23, my lord.
24/2, yes,
My-
read please.
24, 4, my, 24, 23, my lord.
Yes,
Page 72, my lord.
so that representation has been considered now.
No, my lord, there, my lord, can you see, my lord? The order, my lord, page 67, my lord. May I read the particular page 67, my lord?
67, read.
My lord, the petitioner had raised a grievance on the issue of requirement of additional performance security in the work on certain grounds, which however have not been accepted by this court. Thereafter, though there have been other developments in this case, the petitioner had expressed his willingness to make the said deposit, which has been
Okay,
rejected.
the work in question has been retendered,
Yes, Lordship.
My lord.
There were 4 packages.
right? For 3 packages, I
have
think he is
given
not
up.
raising,
Given
he has
up.
given up.
All those were after 3 rounds of litigation, he never got any positive order from this honorable court. Where there is a stay order, that case also he has withdrawn. Case was dismissed.
Sure,
So
right.
there is no operation.
Now he is coming for one package saying that he is ready to pay the,
In the meantime, Lordship, we have issued the retender.
that as per him was during a stay.
Yes.
During the currency of a stay order, you issued the retender. So what is the work?
It was kept in abeyance, Lordship.
Right,
Still, Lordship, we cannot give him because from last year, I think it is August.
Mm.
He is keeping the whole matter pending, and as
On
a result,
hold.
the village roads are not being constructed.
right.
So he does not have any right. On merit, he does not have any right, Lordship. We gave him, he was the L1, we gave him the opportunity. Now, after 5 rounds of litigation, he has come to this point that out of 4, I will give the additional security in 1 case.
APR, APS in one. But this is not a
And the
matter of,
leniency cannot be
now
shown.
this is a matter of writ jurisdiction,
My
sir.
lord, kindly see, my lord, there is the, in fact, there is a reaction, my lord. Page 67, my lord.
Yes,
Court, my lord, specifically stated, my lord, though the rejection by the authorities per se, per se does not appear to be wholly unreasonable, as the work has already been put to retender. Considering the peculiar facts and circumstances,
yes.
this court
To reconsider the matter, they have reconsidered. What is the reason order passed? Let us see.
exercised equitable justice as an
The speaking order is there.
Page 69.
All right, why this order is to be interfered with? The works have suffered because your client could not perform the obligations.
My lord.
How long are the public works to be deferred in this manner
My
on
lord,
account of litigation?
my lord, in the meantime, my lord, they had already retendered, my lord.
Yes, all right, but they have not awarded the work to anyone. But your performance is writ large, you yourself, how many rounds of litigation you have gone into?
My lord, you said, my lord,
Yes,
there are 3 rounds of litigation.
3 rounds,
My lord.
and you are not ready to, they say that we want additional performance security. That demand has been affirmed by this court in division bench, Mr. Saikia. That,
Yes, Lordship.
The-
Yes,
those
Lordship
judgments.
order is there.
yes,
My
Lordship
lord,
was pleased to uphill
yes.
the dismissal order.
my lord, that was,
Page
my
18
lord,
in our.
initial round.
Can we have the copy of the order?
Wants to.
So demand of the additional performance security has been affirmed.
Page
Punch.
18 onwards, Lordship. Page 22 is the portion of the order.
Hmm.
What 37 of that? এখানেও দিছো নাকি?
So the demand of additional performance security has been affirmed. And now you want, now you come out with an alternative mode. So all right,
No,
I
no,
will
my-
pay the APS for one tender, one work. Why?
No, my
They
lord,
want to
because-
get all the works done by another agency.
What happened ultimately, my lord, against the 4 workers, my lord, 4 works, my lord, which were, my lord, was alone, my lord. Against those work, my lord, huge amount was required, my lord. Demand.
You just let us
for
know
additional
whether the court can compel them at this stage to modify the conditions of tender or
No,
to
my lord,
accept a delayed offer of APS.
no, my lord, I am not on that. my
There was
lord.
a
I am-
time-bound schedule.
I am not on that, my lord. I am only, my lord, clear that, my lord, since I have already, my lord, considered all other 3 works, my lord.
Oh, that's
My lord,
very huge
yes.
obligation on the state.
My lord, that is why, my lord, I am confined with only one package, my lord.
Yes,
Now,
one package.
since I am willing to.
They have lost confidence in you.
No, my lord.
Basically,
They
that is
can-
the situation. Yes,
No, my lord, they have.
these are contractual
That is why,
matters.
my lord, they
If you
required. That is
You
why,
filed as L1 in 4.
my lord.
You did not perform the work in any one of them because you did not accede to the demand of the APS.
My
You
lord.
kept on litigating.
My lord.
Litigation ultimately went against you.
My lord.
The consequences writ
My
large.
lord, I am appreciating that, my lord. but-
Even during those appeals, if you had come out with a concession, all right, I'll pay in one, probably you could have succeeded.
My lord.
So there's no question now.
No, now, my lord, since, my lord, I am confined with the only one package, my lord. Now, I am,
Yes.
all other 3, and I am not interested, my lord. I am confined. with
Agitate
only
your
one
cause
package.
in writ petition. In any event, we are not inclined to interfere in non-grant of interim relief by the writ court. There is hardly any scope in the intra-court writ appeal
My
to
lord,
that extent.
otherwise, my lord, if they continue with the NIT, my lord, ultimately, my lord,
They are bound to, they have to get the public works performed.
My lord-
Ultimately, it is the public which suffers
My lord,
because
that
of this
that is why
litigation.
I am ready to willing, my lord. Now, even, my lord.
Go and
since-
satisfy the authorities.
my lord,
Go and
that-
tell the authorities, I am ready to pay the APS.
Yes, my lord, that is why, my lord, I am ready. That is why
But they are not now looking to your conduct. They are not ready to accept.
my lord, what is contact, my lord? I have been already work, this is not the new case, my lord. This is no new works, my lord. I have already having
So
past experience.
applying the
working.
fresh tender process. You have not been blacklisted now. Applying the fresh
My
tender.
lord, moreover, my lord, kindly see, my lord, what are the peculiar facts, my lord? Ultimately, there is prejudice, my lord. We definitely can see, my lord. During the, my lord, I am again defining that interim order, my lord. During that continuation of the interim order, my lord, now they are saying that due to miscommunication with the standing council, that is their particularly, my lord. I am not on that, my lord. During that period also, my lord, they had said that, no, that work has been retendered and you have forfeited, my lord, on the same date, my lord.
No, the representation was disposed of on 22nd. He came to the court for disposal of the representation. We'll dispose of the representation on 27th, and next day, Lordship, matter was, this forfeiture was done.
They can not this
In fact-
package, my lord. My lord,
An interim order was also vacated, page 39.
that interim order, yes, my lord, that interim order vacated, my lord, on the 27/3/2023, my lord.
Yes.
After he withdrew the case.
Yes. Still 27/3/2023, my lord, that order continued, my lord.
Yes, continued. So you will hang them up
Well,
in contempt,
now-
file a contempt. That is the only way out. We will hold them responsible. We'll punish the officers. But in any event, we will not stall the public works in this manner.
No, well, I am ready to, I have.
File a fresh, you file your bid,
My lord,
file your bid in the new process.
my lord,
If you are so
kindly-
inclined,
kindly-
so keen
my
to
lord,
perform the works,
my lord,
file a fresh bid.
kindly appreciate one thing, my lord.
Yes,
Kindly,
yes.
my lord, my prayer, my lord, what my humble submission is there, my lord. My lord, petition has already initiated the work, my lord, on the terms of the LOA, my lord. Initiated work, all the machineries are installed there, all the workmen are still there, my lord. Now, since this litigation process, my lord.
You should not have fought with the demand of the additional performance security. It was an unbalanced bid.
Yes, yes.
But as we see from the order,
Yes, my
it was an unbalanced bid. And in that event, the employer is very much authorized
I appreciate.
to
it.
raise
Yes,
an
yes,
additional demand.
yes.
We are not inclined, sir. You want a dismissal on merits, then your writ petition will be prejudiced. What do you want?
My humble prayer, my lord, only that, my lord. Only since the petitioner is confined only this to this work, my lord. Only to the after.
All right.
Works, my lord.
Dismissed on merits then.
Deeply applied.
Then, my lord, I may be allowed to withdraw, my lord.
And counsel for, after arguing the matter for to some extent, then counsel for the appellant craves liberty to withdraw the instant writ appeal, hence the same is disposed of as withdrawn.
My lord.
We had a bench with Justice Saikya also. He's not come. He was not told about. He's been informed. I know. So but. Yeah, okay. So we'll do it at 2. Inform Justice Saikya then. Yes. All right. Bring the pronouncement matters.
Matter number 1.
That's what I think. The appeal next marital is dismissed.
Matter number 2.
Appeal fails and is dismissed as being void of fact.
Matter number 3.
appeal succeeds, we have allowed it direction to take immediate steps.
সেইটো জাজমেন্ট কাৰ লগত হা
নহ'ব অনলাইন কৰিব আকৌ কাৰেকশ্যন থাকিব পাৰে
দুটাত বহিব ল'ব NIS কেছটো ল'ব কি বস্তু আপনি বেস্টটা কাম করব না এক্সপোর্ট করে দিতে লাস্ট অপারেটিং তার কাইন্ডলি এবার চাই এইটো এই যেটো বেল চলি আছে কাকুৰিয়া মেডামৰ বেলটো শেষ হোৱাৰ পিছত সেইটো কমিটি সজ্জা তাৰ হ'ব আজি আৰু
সেইটো মাৰিব দিছিলো এই ইয়াৰটা আছিলে নহয় 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 এটা কথা মই এইখন মই ইয়াতে ৰাখি থৈছো হা এইখন সেই মোহিত কেছটো মাৰিছে ন বাইদেউ বাইদেউ ভট্টাচাৰ্য বাইদেউ
At 2 p.m. আহি আছো নাই সেইটো ইহঁতৰ ওচৰতে আছে Pronouncement of judgment or order, the readable 52 of 2019.
You have not notified it because this. Has been.
It has been.
Which is.
जान नहीं है, but
अच्छा 2 बजे का. Seen this, this was no. Okay. The appeal fails and is dismissed has been divided by.
One. My lord, oblige.
Item number 1 and 2.
Yes.
Please, your lordship. Lord, we have filed application for correction of typographical error, my lord. Page 14, my lord. WBC number has been typed as 8417. It should be 3417. 3417.
Okay. Interlocutory application number so and so has been filed seeking correction of typographical error in the order dated 18/1/2023 passed by division bench of this court in writ appeal number so and so. The petitioner applicant has pointed out that there has been an error in transcribing the number of the writ petition at page 4 of the order, when it has been recorded that the number of the writ petition has been recorded as 8417/2022, whereas the correct number is writ petition number WPC number 3417/2022. The submissions made in the interlocutory application are justified and hence, the application prayer for correction is accepted. Necessary correction shall be incorporated in the order dated so and so, which shall now read as below. We transcribe the entire order wherein this number will come, correct number will come. What is the review about?
Item number 3.
Item 2, my lord, same order. I want small modification of that order. My lord, your lordship, can you see page 31 of that review?
Review, page 31.
Page 31.
Please, item number 2.
2.
Yes.
Page 31, your lordship, kindly see. Second paragraph,
31. Okay.
it was start from last line.
Yes.
It has been submitted at the bar that the matter has been amicably settled.
Mm.
In view of the above settlement arrived at between the parties, the impugn order dated 29.
Same writ petition number.
Same review, same matter. Now it is modified that order also.
3417.
3417.
Same
But
order,
no, it's not, my lordship, slightly defined manner. It is written that it will become ineffective.
That would be.
That cannot be, my lord, that ineffective of the, my lord, that writ petition, my lord. It can be effective. Because the appeal was filed against this order.
Will become effective.
Here it is written ineffective, it will not
Yes.
be ineffective. Ineffective means, my lord, that order also goes, this Larned's trial, single bench order.
No, the intent is very clear, will become ineffective except for the questions of law.
My lord.
So that means the division bench has clearly indicated
But
that other than the questions of law, which may be decided in other appropriate proceedings,
that is,
any of the observations made in the order
but,
are set at naught. That is what the intention is.
but how, my lord, this amicable settlement can, my lord, become ineffective of the Larned single bench.
Writ
That is-
writ petition, even the writ petition can be withdrawn in
Yes.
appeal. So that is permissible. So in effect, the order of the Larned single bench has been set at naught by the settlement between the parties.
My lord.
That
I
is what the
said,
effect is.
Even it is not the settlement between the parties also.
We don't know, sir, that is what was stated in the court. And on the basis of such statement,
But
this
it
fact
is-
was recorded.
but it is also written that we are not the party to that settlement.
Who?
It is observed that present applicants. Second
Where is
line,
it written?
Here also.
11 and 15 submits that he is not a part of any settlement.
Here also, my, there are the directions to conduct the convene the meeting within 15 days.
Right.
They did not. Against that, they filed appeal, and appeal has been withdrawn. And it is also stated that that order will be in effect. Then if they convene the meeting, we have no.
But the appeal has been withdrawn.
Withdrawn.
What is the direction in the single bench?
Single, there are the directions to convene the meeting within 15 days. Your lordship can.
But then the persons who have moved the motion,
My lord.
if majority of them say that, no, we don't want to go through it.
That is correct, but now at situations may change, my lord. That is the.
Situation may change, file a fresh motion, move a fresh motion after 6 months.
Not,
6 months are coming to an end now.
No, sir, that will not be, my lord, bar for that.
Then,
But question is, there is directions that they will convey. the-
sir, you did not file a cross appeal here.
That is correct.
So then you are no one to say that the appeal should not be withdrawn.
No, I'm not saying the withdrawn, because we are not the
Nothing beyond that.
party
Nothing.
of that amicable
Only
settlement.
correction in the, so the order was not against your interest, basically. The appellant said, all right, we are not inclined to continue.
My,
You could have filed an appeal in your own capacity. And you could have pursued the matter.
here appeal is, my lord, withdrawn, my lord, I have no objection, but that Larned single bench order,
So
that.
obviously, the direct result is that the persons who had moved the no confidence motion, they did not want it to be carried through. So obviously, the direction of single bench became ineffective as a consequence.
But one thing, my lord, we are not parties to that amicable settlement, and government is also not.
Maybe, so all right, you file an independent appeal with delay condonation. That's what the remedy is for you.
But that liberty, my
Reviews
lord,
in view of the fact that the appellants applicants herein have filed the instant review petition.
13.
Seeking a review of the order dated so and so passed by this court in so and so. We find that the order was passed on the basis of settlement between the contesting parties, and as such, the applicants herein who were respondents in the appeal, could not have objected to the disposal of the appeal in that manner, since, they did not challenge the order of the single bench independently. Consequently, other than the correction in the clerical typographical error in the impugn judgment, which we have already allowed in connected IA number so and so, comma, there is no reason to interfere in this review petition, which is dismissed as being devoid of merit.
Item number 3 for orders.
Please, your lordship. Lordship, I am pray for adjournment today, lordship.
What is the application?
Application is for correction of name, lordship, petitioner name.
So then why?
Lordship, engaged counsel is, I am not engaged counsel in this matter, lordship. He is in.
But if you want simply a correction of name,
Yes, lordship.
why you want an adjournment? Correction of name on what ground?
Petitioner's name was recorded in writ petitioner, lordship, Hemodi Moran, lordship. It should be Hetami Moran.
Correction of name where?
Petitioner.
In the writ petition, they have wrongly recorded.
Writ petition. That was disposed of.
Writ petition has been disposed of with the order, lordship, as the name was reflected in the writ petition.
Naturally,
They want a correction in the.
where is the file of the writ petition? So you want instead of Bohagi Chitia, the name should be Hitami Moran.
No, no, lordship.
Then-
The petitioner number, petitioner number.
Petition number 2.
Petitioner number 2.
Hemodi Moran,
Yes, lordship.
wife of Monai Moran. But what is the material to support this prayer for correction, please? How would you satisfy the court that the correct name, and what difference is it going to make? Compensation, that is why. Ms. Chaudhary, you respond to this application. Find out whether the prayer is genuine or not.
To find out the name, lordship, perhaps the deputy commissioner can do it. In Sukia. We are only the paying authority.
Deputy Commissioner is a party in this.
The deputy commissioner Tinsukia is a party.
All right, verification of the government, council, land council students, so praise for time. Verification of the amendments made in the application shall be made by the respondent number 6, Deputy Commissioner Tinsukia. Land Council MSM Bhattacharjee shall place the verification report supported by an affidavit on record by next date, list after 3 weeks. Today is 28th. Oh, give me a fresh first page. The appeal fails and is dismissed, being devoid of merit. Is change kara dejiye. When we do it this way, you have to get this signature of the getting that before. That's all.
Pronouncement of judgment. Matrimonial appeal 8 of 2014.
The appeal is accordingly dismissed.
For hearing, item number 4252.
But as your lordship desired, we checked up the record. We found something relevant. We have applied for certified copy. Okay, replacing it next.
Sure. See, we were continuing with the point-wise discussion of
Yes.
accused number
Accused number 3.
three.
In fact, my lord, the submission that I'm making before your lordship, except the first part, rest is because of the leg of octopus, that is 120B, I have to go into everything, all the acts that has been attributed. And my lord, I submitted before your lordship, the second act which was attributed was defalcation, and I said that it is covered. It has
It's
been
a different trial which is
different
going
trial.
on. Yes.
For that. Thereafter, my lord, I placed this.
But just a small query at this
My lord.
stage. Whether there is any finding of the learned trial court on the charge or allegation of defalcation in this judgment.
No, my lord.
There's
yes,
no finding.
He said that there was defalcation.
Okay,
He said, but specifically, I will.
without there being a charge,
My lord.
without there being a charge.
Yes.
There's a charge, of
Yes,
course.
My lord,
There is a vaguely,
there
there is an allegation in the charge.
allegation is there
Right.
because that too, just to show that we had money.
All right.
That's all. Otherwise, there is no charge under PCX, there is no charge under misappropriation.
Right.
Section 40.
467,409,
No-
nothing.
There is nothing.
Yes.
Now, my lord, the third one that I act that was attributed was that the accused number 3, my lord, sent money through PW 35, 106 and 120 and 21. That I have placed both and there is nothing on record which shows.
Right.
Then, my lord, I
Keep
submitted
on
before a lot.
noting the arguments when once they start. Yes. Yes.
Then, my lord, submitted before your lordship, the findings specifically in paragraph 106 Roman 2 and 106 Roman 3 of the judgment, wherein, my lord, I showed to your lordship that
Corroboration of the evidence
yes.
of the other
Other.
accused
yes,
by the 164
My
CRPC statement
that-
of
absolutely. And then I submitted that it is, my lord, section 157 of the Evidence Act. And I also submitted, my lord, cited two decisions, R. Saji and Sasi Jaina Vikrami.
Okay.
Then, my lord, I refer to paragraph 109, the concluding part where the learned trial court said that the allegation, the act that I have sent the money is proved by PW 35, 21 and 106.
Right.
At page 109. And I said, my lord, with all respect, that the finding is forward, but not supported by the evidence. Then, my lord, the next point that acquisition rather that I submitted is the allegation that after the money reached Calcutta, it was handed over to accused 12, 13 and 14. I submitted that there is no evidence.
No evidence.
This has not even been discussed. Subject to, they will show, my lord.
there is no finding on
There is
that
no
aspect
finding.
also. Okay.
According to me, there is no finding.
Okay.
Then, my lord, the next one is that after receipt of money, accused number 12, 13 and 14 gave it to A1. Accused number 1, Fajinder Hojai in Calcutta. Now, my submission was that the money did not move from Guwahati.
Move from God.
It did not reach accused 12, 13 and 14. Here is the question of accused 12, 13 handing over money to accused number 1.
Or being used in terrorist acts.
My lord. Then, my lord, the next was that accused number 9, that lady Malsa Kimi, she collected money from accused number 1. Now, there is no evidence Malsa Kimi denies. Now, then comes the
Malsakini is an accused, of course.
accused number 9.
So, right.
Now, she denies in her 303 examination, 333 CRP examination. She denies there is no evidence except PW 29, who was accused number 10 and has been made approver.
All right.
And this approver, my lord, made an exculpatory confessional statement. He also made a statement before the court as PW 29. That also is exculpatory. He says, I'm not a colleague. I have just taken commission and converted the money. And there, my lord, I submitted before your lordship. Pakla Narayan, your lordship knows, so I did not place it. Your lordship is well aware. With
No,
Pakla
it's always good to revise.
my lord. Then, my lord, Pakla Narayan, your lordship may have my compilation if your lordship.
Compilation.
ये निकालने क्यों नहीं my lord, page 49, my lord, of my compilation.
And this is not the evidence part, compilation of judgment.
Compilation of judgment, my lord. It's in blue. That's the one. That's the one. Blue one.
Yes, page 42.
Madam, my lord, the relevant portion, your lordship will find at page 15. नहीं है तुम लोग
50.
So, this is at page 44, my lord.
Yes.
Relevant, my lord, will get at page 15.
Yes.
Page 50. 50, your lordship got 8 lines from the top.
Yes.
The relevant code. As the point was argued, however, as there seems to have some discussion in the Indian court on the matter, it may be useful to state that in their lordship's view, no statement that contains self-exculpatory matter can amount to a conflict. If exculpatory statement is of the same fact, which if true would negate the offense alleged to be confessed. Moreover, confession must either admit in terms of the offense or at any rate substantially all the facts which constitute the offense. This is important, my lord. An admission of a gravely incriminating fact, even conclusively incriminating fact, is not itself a confession.
This is dealing with the confession of the accused.
With the confession.
Not with the statement of the accomplice.
That I'll come to. For that, I refer to, my lord, Ravinder Singh versus State of Haryana. That, my lord, will get at page 113 of the compilation.
Yes.
This is the relevant would be, my lord, paragraph 12 at page 118. Page 118. 12 is the last part. The approver is a most unworthy friend, if at all, and he, having bargained for his immunity, must prove his worthiness for credibility in the court. The test is fulfilled, firstly, if the story he relates involves him.
So he should state the facts which make him privy to the crime.
Absolutely.
Without that,
Yes.
the evidence
Yes.
can't be treated to be evidence of an accomplice.
In the crime and appears intrinsically to be natural and probable catalogue of events that had taken place. The story is given of a minute detail, according with the reality is likely to save it from being rejected as brazy money. Secondly, once that hurdle is crossed, the story given by an approval, so far as the accused on trial is concerned, must implicate him in such a manner as to give rise to a conclusion of guilt beyond reasonable doubt. In a rare case, taking into consideration all the factors, circumstances, and situation governing a particular case, conviction based on uncorroborated evidence of an approver, confidently held to be true and reliable by the court, may be permissible. Ordinarily, however, an approver's statement has to be corroborated in material particulars, bridging closely the distance between the crime and the criminal. certain clinching feature of the involvement disclosed by an approver appertaining directly to an accused, if reliable by the touchstone of other independent credible evidence, would give the needed assurance of acceptance of his testimony on which a conviction may be based. Now here, he doesn't have placed that his part. He says, I'm not concerned, I'm not their colleague, I have just taken commission and converted it. Even that statement, my lord, I will show from the evidence on record that is not reliable at all, that he has converted. He may be converting some small amount here and there, that's a different thing, that is how they caught them. Accused number 10 and 9, they were doing this business. They were helping people, they were doing these things, my lord, converting, getting some money from the, my lord, the person who deals in foreign exchange has to get a license under the Foreign Exchange Management Act 1900.
Not official dealing, sir.
My lord?
This is underhand dealing.
That's right. That's what I'm saying.
So there's
No, that's what I'm saying. But my lord, to convert 4 crores, unofficial dealing would not be to this extent. And when you know
4 crore official dealing, we
unofficial
don't think
dealing,
it's possible.
unofficial
4
dealing,
crores of conversion of official income
yes,
would not be possible.
my lord. My lord,
That
what-
would bring
what- what
bring
we-
bring about many consequences.
My lord, what I know little about it, I've been told and doing these cases. My lord, if the money is to be sent to foreign country, now there is a lot of restrictions, lot of strict thing. Earlier, it used to be by Hawala.
Obviously,
The code word will be given to you or a page will be given, you
Right.
take it to Singapore.
part of the
you
note.
take it-
Part of the note.
Yes, a part of the note, take it to Singapore. Why go and take such a round, my lord,
Circuitous
circle?
route.
Why this?
Guwahati, Calcutta, then
Yes.
Calcutta to Shillong.
No, no, that is not, that was seized. And that money is also not produced. That also is in evidence.
Hopefully it escaped the rigor of 8 November 2016.
Now, these are the things which I placed, my lord, the other day. Now, today, my lord, the lordship permit, I'll place, my lord, because I submitted, my lord, while placing the statement of PW 27.
29.
Sorry, 29, that my lord, accused number 9 and PW 29 and accused number 10, they collected money from Mohit Hojai. Now, PW 29 says that I don't know who
Mohit
he
Hojai
is.
is.
Even Malsakivi did not know, even accused. So they were collecting from a stranger. And it's not in the evidence that there was something by which we will identify. You may not know, but there must be something to identify each other so that you are dealing in crores. There is nothing on record. Now, to avoid that, to overcome that difficulty, they brought in identification in the police station.
Right.
Now, your lordship asked me yesterday, a day before, that accused number 1 was on bail. Subsequently, I have found out, my lord, from the record that his bail was cancelled, but that was after the identification. Yes. Now, the condition of the bail was that he will be called as and when required.
As and
he
when
will have to
required.
come.
Right.
He says, I received a call, they called me, so I went. He has given that instruction to the council. So, my lord, they had 2 identification done in their SOU, that is Special Operation Unit Police Station itself. One is 77, Exhibit 77, which my lord will find at Exhibit 3 paper book. Exhibit 3 paper book. Nikalo. 3.
Volume 3.
Yes, my lord. Volume 3.
At page.
My lord, this is at page 512.
Right.
Page 512. I was showing this, then your lordship asked me who are the witnesses at that point of time. The hearing was concluded for that day. 5112, my lord has got.
Yes.
I'll please. It therefore mentioned, the above mentioned accused are the, above mentioned are the accused George Lamthang. This time he was not given pardon, my lord, if you tell. This is, on 18th of August 2009, this identification. George Lamthang, late so-and-so, was shown a person unknown or Fajinder Hojai, or known as Fajinder Hojai. The same person from whom he, along with Malsa Kini, had collected money from Madhu Milan Hotel and Salimar Hotel of Calcutta in presence of executive magistrate and independent witnesses at SOU police station on 18/8/2009. The said accused identified the person who read identity, whose real identity is Fajinder Hojai, son of so-and-so, so-and-so. Now, this is done. The witnesses are, one is Mr. C.P. Phukan, he is executive magistrate. The other is S.I. Lanta, and then S.P. Pani, he is an NIA investigator. And then one assistant inspector of excise, he is Navajit Buragohai. Now, similar, I will place another exhibit 119, and then I will place, my lord, my submission on it. Now, my lord, by exhibit 119, accused number 9 was made to identify Fajinder Hojai, because they are the one who were collecting money. So to overcome all this, it was done. Now, my lord will see page 662. Paper book 3, which your lordship was having, exhibit paper book.
Get the AC switched off for a minute.
3.
Page number?
662.
662.
Exhibit paper book.
Yes, identification memo.
My lord. Not all similar, except that this by Malsa Kini, I'll place few lines. The above mentioned, the accused Malsa Kini, so-and-so, shown a person known as Fajinder Hojai, the same person from whom she, along with George Lamthang, had collected money from Madhu Milan Hotel. And
The date is 22nd July 2009.
This is, my lord.
What is the date? 18/8/2009.
Yes, same day, my lord.
Were the accused in police custody at that point of time?
No, others were, my lord, in custody.
What kind of custody, sir? There's a pertinent reason for this query.
Yes.
What was the date? What is the date of arrest? Can we again
lord,
have a look at that chart?
Chart sheet.
The chart then.
Chart sheet. It is in the chart sheet.
वो चार्ट दिया था ना वो देना Malsakini was arrested on 11/8. Yes, so presumably it is only on the 7th day.
Yes.
So we can assume that she was in police custody. Otherwise, how could she be at the police station?
That's right. There has to be a permission from the magistrate. And George Lamthang was arrested on 12/8, one day.
Right.
Okay. One day after Malsa Kini. So they were in police custody. Because then, my lord, so Malsa Kini, it shows that Malsa Kini identified a person known as Fajinder Hojai. Now,
Yes.
my lord, the legal submissions which I will there is an order, your lordship is correct. There is an order of 14/8/2009 remanding them to police custody.
There must be,
15
obviously.
days, yes. Now, my lord, my first objection to it is, before your lordship, if your lordship requires, I will definitely take your lordship through the evidence. But, my lord, your lordship kindly have Evidence Act, paragraph 26. Sorry, section 26.
This is a hit as per you.
Yes, this is hit by section 26.
So confession in custody.
In custody, it says that the exception is.
Exculpatory part, can
Magistrate.
it not be a discovery of fact under 27?
No,
Because if you see
Yes.
a document at page 63, 663,
My lord,
this is in furtherance of a 27 information.
my lord,
No, please read at page 661.
my lord. This is 661 is, my lord, a declaration which was obtained.
No. This is the order of the magistrate whereby he has given permission to hold this identification parade. And in this itself, there is a reference of a disclosure of this accused, Malsakini. Please
No,
read
that this one, I have not got which one you're.
page 661 in this exhibits, just before the identification.
My lord, identification is at 662
Yes, so just
and
read
661.
one.
That's
Yes.
what I'm saying, In the above mentioned case, accused Vanlal Chana, this is Vanlal Chana,
Mm.
Vantia so and so, in presence of Sri Navajoti Buragohai, Assistant Inspector of Excise, Kamrup Metro, to the Assistant IO of the case, Santosh Kumar, Inspector of Police, NIA, New Delhi. The disclose made by the accused is recorded in Mizo language.
Mm.
It's not a statement, my lord, disclosure under 26. This is a disclosure that Malsa Kimi, and I'll just read out the English translated.
I know a lady named Swami.
Yeah.
She stays in
stays in
Aizawl. She
Aizawl.
along with another person,
Thanga.
Ganga, used to convert
PW.
Indian rupees to
Yes.
so and so.
This is
Your
a
permit-
statement. This is
This
not,
is a statement, not
Yes,
not a disclosure.
no, it's not a.
Okay. Yes,
Now,
evidence.
now, my lord, if your lordship has seen 662, exhibit 77, as well as my lord, no, sorry, exhibit 77 at page
When
512.
the one accused says, I am identifying the second accused and it is taken down in writing, it is a statement of an accused made in the presence of police officer. That's what the argument you are raising.
No, here because they say it was made in presence of an executive magistrate.
But the police officers were also present.
Yes.
That is why
Now, therefore,
26.
your lordship will kindly come to section 26.
Yes.
Confession made by accused while in custody of police not to be proved against him. No confession made by any person while he is in the police custody of a police officer. Now, this is important, unless it be made in immediate presence of the magistrate and shall be proved against such person.
Okay.
Now, therefore, what they claim is that the executive magistrate was there and this statement is made, therefore it will not be hit by 26. Now, my lord, there is a full bench decision of this court, which says that the expression magistrate, which has been used in section 26, means only a judicial magistrate. That decision, my lord, I have enclosed. This is Karthik Chakravarti, 2017 5 GLT, page 144.
Probably this presumes this section indicates a magistrate who is competent to record a confession.
Absolutely. Your lordship is, yes.
That must be the ratio.
Yes.
Mostly, yes.
That, my lord, even before 1870, when old CRPC, like we've got 18, there also, the magistrate is separately defined, and the executive magistrate, they are my lord, named by their designation, and they are executive magistrate. And plus, my lord, if your lordship will come to subsection 3 of section 3 of the CRPC.
Yes.
My lord, section 3 of CRPC starts with construction of references. My lord, Sati. In this code, now your lordship will come to subsection 3. Unless context otherwise required, any reference to any enactment passed before the commencement of this act. Evidence Act is one such act, 1873. 1A, to a magistrate of first class shall be construed as a reference to a judicial magistrate of first class. Now, these have been relied, and thereafter our full bench, my lord,
Which-
decided at page 104 of the compilation of judgment, if my lord will kindly turn to.
AC, man, switch off the AC. Chal
Hmm?
na.
104?
For a while. Yes, 104.
104, Karthik Chakravarti. My lord, paragraph 1, I will take your lordships to show what was the issue before the honorable full bench. At 105, the top line, the two appeals are before us on a reference made by a division bench of this court to examine and decide the following question of law. Whether the expression magistrate appearing in section 26 of the Evidence Act would mean judicial magistrate or an executive magistrate. Now, straightway, my lord may come to paragraph 35. Oh, sorry. 36, my lord. 112. Page 112. Consequently, we hold that decision in Anupam Das lays down correct legal proposition, and accordingly, we answer the reference by holding the expression magistrate appearing in section 26 of the Evidence Act would mean only a judicial magistrate and not an executive magistrate.
So that is what the observation, if you see at page number 27, then running para 20, page 110, running para 27 of Anupam Das.
Yes, my lord, because that was a division bench judgment, and the other division bench
The
judgment.
observation of the cuff which we made,
Yes.
that the magistrate should be competent to record a confession.
Well, that's what I
That is what
said.
the observation is.
When that fell from your lordship, I said, yes, that's the crux. That is what is mentioned in the earlier, unfortunately, they have not brought it. Because the person should be competent to record confession.
Record confession.
Because otherwise, what will happen, my lord, for a confessional statement, so much precaution is taken
Precautions
by
are
the
required.
statute, plus the law laid down by your lordships, over and above what is prescribed. Your lordship has laid down other conditions. And here is the case where in police station, you get a executive magistrate, he will sign, and then it is over. That cannot be permitted. Therefore, in my humble submission, exhibit 77 and exhibit 119.
Otherwise also, one more observation.
My lord.
So far as identification by Malsakini is concerned, because assuming that this is a TIP, that is not a substantive piece of evidence.
Absolutely, my lord.
So the identification would have to be in the court, which Malsakini could not, because
Yes.
she is an accused
My lord,
regarding that what George,
George.
his identification, they would be relying upon by virtue of this so-called identification proceeding,
Well,
which as per you is hit by 26.
26. My lord, what has just fallen from your lordship, I have a decision on the point. I just brought it, and now since your lordship says you should produce, I'll place. This is a decision of 2021. Where I have it? I don't know. 2021. A recent decision, my lord. PIP credit. PIP credit. 2021 निकालो. This is, my lord, your lordship will kindly come to 136 of the judgment paper book.
Yes.
This is Rajesh alias Sarkari and other state of Haryana. The relevant portion will be, my lord, page 138.
Yes.
4.39. Since PI parade does not constitute substantive evidence, the failure to hold it doesn't ipso facto make evidence of identification inadmissible. But what remains is that it's not a substantive evidence, as you know.
Identification has to be in court.
Yes. Now, on 25th/11, if I remember the date correctly, Kojinder Hojai was produced. He was in the court. And there he was identified. But before that, this has already happened
He was identified,
by the accused,
George.
George. But before that, 18/8, there was already, and
So-
he also, George also says that just before I came, his
So the
photograph was.
argument probably would build up is that the accused was shown to the witness
Yes,
in the police.
that is there. That is there on record. On record. So there also there are so many things, fellow. Now,
Probably they have fallen into a trap by doing this exercise.
Masha. Now, my lord.
Often question the veracity of the DIP by the argument that the accused was shown to the witness in the police before the DIP was. Document बनाया ना. Yes.
Well, your lordship, I don't know if your lordship will remember. Paragraph PW 29, in his statement, starting from 158 to 149, every line, every paragraph, he says, I got the money converted through Tapon. I had, and all that conversion, he did it, I don't know. Because he was giving money to Tapan, he used to take 10 days and convert it and give it. Now I asked a question to myself, who is Tapan? Such an important person who has converted 4 crores, more than 4 crores. In fact, Deepalal Hojai, there is an evidence. That time also it was coming according to them. So who is this person? Then I could find out that George has made a statement who he is. Your lordship will kindly take George's statement at 148, volume 1 paper book. Paper book.
Relevant exhibit, page number 57.
Here. Yes, it is. Okay, that evidence,
Yes.
evidence, brown color. This is 148 as he has tidied.
No, we are having independently George statement we are having.
Yesterday, your lordship had given that we have also, yes.
That is page 57.
Yes.
My copy, my lord, after the bail was rejected, it was gone to Supreme Court, it had gone, so they had taken that.
Okay.
So at page 57.
Yes.
Now 57, your lordship will come to 59. 59. In April 2009, May 2009, June 2009, July 2009, Malsa Kimi brought 15 lakhs from Aizawl and converted into US dollar. On each occasion, I converted the money into US dollar through Tapan. In the same way, I kept my commission. I did not have any knowledge about her further transaction with money. Before that, my lord, just Tapan I wanted to show to your lordship. At page 57, my lord, second paragraph, third line, if you, my lord, will see. In April 2008, Malsa Kimi asked me whether I have any idea of conversion of Indian rupees to US dollar. At that time, I didn't have any such contact. I informed her that when I have contact. In June 2008, I came to know with Tapan, who is a money changer. And everywhere your lordship will find that he has done this exchange through Tapan. Every paragraph, my lord. Now, I asked a question to myself, who is this Tapan? So, in cross-examination of PW 29, your lordship will see at page number 52. My lord, at page 61.
Yes.
Cross-examination, the first paragraph. I have given evidence in this court on the basis of confessional statement given at the time of investigation while I was in judicial custody. It is not a fact that I have given confessional statement under the threat or being tutored by NIA officials. The person who referred whom I referred as Tapan in my evidence was arrested in Calcutta in connection with the present case. Well, kindly mark. He was arrested in the present case. And yet, nothing was done to interrogate him, to find out from him from where he is converting such huge amount. After all, my lord, if you
Question must have been put to the IO in cross-examination.
yes. Now, my lord, will come to the IO CW 150, Mr. Mukesh Singh. It starts, my lord, from page number 236 of the
Yes.
lordship's paper book. 286. Now, the relevant portion my lord, at page number 280, your lordship will come first. 280.
280, yes.
Under the third para. I have visited Kolkata.
Yes.
I have visited Kolkata in connection with this case, but during my investigation, I have not seized any dollar from any person. I have not examined any dollar exchange person by the name Tapan, even though his name surfaced during investigation. Then my lord will come to page 283. 283. Cross-examination by Molsakimi, fourth line. During investigation, my lord got it. During investigation, George Lamthang had disclosed that one Tapan Das was the person who converted rupees into dollars. I have not personally made any endeavor to arrest Tapan Das. I am not aware of the arrest of Tapan Das. Now, if lordship permit me, for a second I place Foreign Exchange and Management Act. Foreign Exchange and Management Act 1999, just for your lordships. Because my lord, exchange of 4 crores by this man, my lord, is directly related to national security. He can convert any amount of money, dollar, and hand over to terrorists. It's national.
Your argument is that why he was granted pardon? He should have been made the prime accused.
George, my lord,
George.
no, Tapan and
Tapan.
Talking of Tapan, at least, my lord, Tapan may be, he's not a money changer. He may not be a money changer. He may be a person go between. He must be getting it exchanged through the registered, my lord, those licensees who have been given license by the RBI.
But anyhow, even investigation was required to be conducted.
Yes.
In this slide, yes.
That's right. My lord, your lordship will kindly come to section 10.
Yes.
Section 10. Section 10, my lord, explains the expression authorized person. Reserve Bank may, on an application made to it in this behalf, authorize any person to be known as authorized person to deal in foreign exchange or in foreign security as an authorized dealer, money changer, or offshore banking unit, or in any manner as it deems fit. The authorization under this section shall be in writing and so and so. So this person must be getting from him.
How can we presume that? These are all underhand dealings. It is not a
all right,
very well kept secret that these kinds of transactions in foreign currencies, they don't take place through authorized dealers.
My lord, when
They are all clandestine transactions.
when an investigation is being made and the allegation is
To that extent, you are right, that investigation ought to have been done from Tapan for the reason that he was the person who was a cog in the entire transaction of exchange, conversion of Indian money into US dollars.
but they have not done it. There is reason for it. In fact, I thought this sentence I will not utter now. I had kept it because when I go to recovery of the weapons, I would say, but now, my lord, if your lordship permit me, I will say They have not examined Tapan because this is not a prosecution story based on evidence, but this is a scripted story based on fiction. This is just a fiction, my lord, without any evidence whatsoever. My learned friend may shoot your lordship when his turn comes. Then, my lord, now, my lord, if your lordship permit me, I'll place the entire evidence of PW 29, what he has stated. So long I have given, my lord, just the relevant portion. Your lordship will take volume 1 of paper book. Oh, it is, sorry, my lord, page 57. Your lordship just had it. I'll place the whole thing. I belong to Manipur, and since 2006, I had been settling in Kolkata along with my family consisting of my wife and 2 children. Initially, I was working as travel agent as well as commission agent. Later, I was doing the job of money exchange on commission basis to money exchanger which Tapan in Calcutta. Since I was doing the job of procuring air tickets, I came to know co-accused Ms. Malsa Kemi in January 2008. Since then, I used to facilitate travel tickets whenever she approached me for the same. One day in April 2008, Malsa Kemi asked me whether I have any idea about conversion of Indian rupees to US dollar. At that time, I didn't have any contact, and I informed her that I have contact. I informed her that when I have contact, I will inform you. In June 2008, I came to know with Tapan, who is a money changer. One day I was sitting in a roadside tea shop nearby New Market. I heard the 2 persons discussing about conversion of US dollar, and I got introduced myself to one of the person whose name is Tapan. We exchanged our phone numbers, and since then I used to contact him. In the month of August 2008, I informed Malsa Kemi that now I have got contact for conversion of rupees to dollars. In the same month and same year, Malsa Kemi brought 15 lakhs from Aizawl for conversion to US dollar. Then I contacted Tapan and started converting rupees into dollars with the help of Tapan. It took 3 days to complete the conversion. After completion of conversion, I kept my commission at the rate of 15 paisa per dollar, and I returned converted money to Malsa Kemi. This way, she normally used to bring 15 to 20 lakhs per conversion to US dollar from Aizawl almost in a month. In the month of October 2008, Malsa Kemi brought 20 lakhs for conversion to US dollar from Aizawl. When I visited her at hotel room at Central Point Hotel, Kolkata, to collect Indian rupees, on that occasion, I saw accused Vanlal Chhana staying with Malsa Kemi at the hotel, but I did not know Vanlal Chhana. He's accused number 8, my lord, the so-called arms smuggler. And Malsa Kemi introduced him to me as Vantia of Aizawl. After collecting money from Malsa Kemi, I left the hotel and I went to my rented house with the money in Kolkata. Then I contacted Tapan. As before, I exchanged the money through Tapan. It took around 3 to 4 days to complete the conversion. In the same way, I kept my commission at the rate of 15 paisa per US dollar and returned the converted money to Malsa Kemi. In November 2009, Malsa Kemi came to Calcutta and asked me to accompany her to Madhumilan Hotel to collect money of Vanlal Chhana. And both of us went to Madhumilan Hotel at Calcutta, from where Malsa Kemi collected 1 crore from Khojinder Hojai. But at that time, I did not know Khojinder Hojai. After Malsa Kemi collected the money, both of us headed to my rented house, Calcutta, from where we counted the money in detail and we found it to be 1 crore. After that, Malsa Kemi left for hotel. I started converting money to US dollar with the help of Tapan. It took about 10 days for converting the said money. After completion of the conversion, I handed over the US dollar to Malsa Kemi. In the same way, I kept my commission. Again, in February 2009, Malsa Kemi came to Calcutta and asked me to accompany her to Madhumilan Hotel at Calcutta, from where she collected rupees 2 crores from Khojinder Hojai. At that time, I did not know Khojinder Hojai. After receiving money, both of us headed to my rented house at Calcutta, from where we counted the money in detail and we found it to be 2 crores. After that, Malsa Kemi left for her hotel and started converting money to US dollar with the help of Tapan. It took around 20 days to convert the said money. After completion of conversion, I handed it over the US dollar to Malsa TV. In the same way, I kept my commission. On this occasion, I saw Vansia for the second time when I visited Malsa TV at Central Point Hotel to give converted money. Again, in the March 2009, Malsa TV came to Calcutta and asked me to accompany her to Shalimar Hotel, Calcutta, from where she collected 1 crore from Fajinder Hojai. At that time, I did not know Fajinder Hojai. After receiving the money, we both headed to Central Point Hotel, Calcutta, where Malsa TV stayed. We counted the money in detail and we found to be 1 crore. After that, I took money to my rented house and started converting money into US dollar with the help of Tapan. It took 10 days for converting the said money. After completion of conversion, I handed it over dollar to Malsa TV. In the same way, I kept my commission. Although I was accompanying Malsa TV to the said hotel, I did not have any knowledge about Fajinder Hojai, from where Malsa Kimi collected money on 3 occasions. Even Malsa Kimi did not have any knowledge of Fajinder Hojai. That is how, my lord, Exhibit 77 and 119 was pressed into service. I learned from Malsa Kimi that she was collecting money at the behest of one Lal Chana. So this is also another, Malsa Kimi told, he's saying. I was simply accompanying Malsa TV when she said that she had money to be converted and she had to collect money from a person in hotel. In April 2009, May 2009, and June 2009, July 2009, Malsa Kimi brought 15 lakhs from Aizol for conversion into US dollar. On each occasion, I converted the money into US dollars to Tapan. In the same way, I kept my commission. I gave US dollar to Malsa Kimi. I did not have any knowledge about her further transaction with money. So here, my lord, I submitted before your lordship that there is no evidence that Malsa Kimi gave it to the so-called arms smuggler, A10. Because George also says, I don't know. If at all George's statement is taken into account.
Right.
I learned from Malsa Kimi on each occasion that she had been sent by a businessman in
Even if the statement of George is to be believed, it is only probably the offense under FEMA or the FERA, as the case may be.
I was arrested on 11/8/2009 by Calcutta police. The police seized 5 lakhs from my possession, which I was given to me by Malsa Kimi on 7/8/2009. But she did not tell me what to do with the money, as she said that she would let me know what to do with the money. Here, my lord, my lord, one thing I have noticed that whether it is pointing out memo showing this is the hotel, that is also in 27. Now, everything is under 27, including this, my lord, that George made a statement after his arrest that I have kept 5 lakhs in my house. I'll give it to you. But he said that these are my ancestral property. He has made in that, if at all that is to be believed. Because your lordship is well aware, section 27. Only those persons, those portion of the 161 statement, which distinctly relate to discovery of the object. Only that much. But here I will show, my lord, exhibit 43, they have written story. Then I admit that I converted rupees to dollar. Your lordship, this is important. But I am not a colleague of any of the accused. At this stage, only his, my lord, pardon should have been cancelled. I was only a commission agent working only to get a little commission to be able to maintain my family. On 28/2009, I made a statement under 164 before the Judicial Magistrate, Guwahati. Today, I have gone through this statement and I say that same was recorded as per my statement. Exhibit 76 is the said statement. And so I'm a signature. Exhibit 77 is the identification memo dated 18/8/2009 by which I have pointed out Hotel Madhu Milan and Hotel Shalimar, from where, along with Malsa Kimi, I collected money for conversion from person Fajinder Hojai. I have placed already, my lord, exhibit 77. Exhibit 78 is disclosure statement made by me to NIA disclosing a sum of 5 lakhs was kept in my residence. I refer to this here in the conversation. Exhibit 78. Exhibit 79 is the disclosure statement made by me disclosing that I, along with Malsa Kimi, went to Madhu Milan and Shalimar for the purpose of collection of money. Exhibit 52 is pointing out to Madhu Milan house NIA officer when I visited so and so. Exhibit 80 is another pointing out memo where I pointed out Hotel Shalimar to so and so, as if these are in his exclusive knowledge. Exhibit 81 is production memo by which passport bearing so and so and mobile phone so and so is were handed over to my wife. Exhibit 81 is her signature.
Yes, correct.
I'm now, my lord, on cross-examination. I have placed this page number 61. I have given evidence in this court on the basis of confessional statement given at the time of investigation while I was in judicial custody. It is not a fact that I have given confessional statement in a threat or being future by NIA officials. The person whom I referred as Tapan in my evidence was arrested in Kolkata in connection with the present case. Regarding conversion of money from Indian currency to US dollar, the whole transaction was done by Tapan. I do not know how much commission Malsakimi took for converting Indian currency to US dollar. I do not know what purpose the aforesaid US dollar will be used by whom and for what purpose. On 8/5/2013, on the basis of my application, I was taken to Guwahati Medical College Hospital at psychiatric OPD for sleeping disorder, and I was prescribed medicine for the said treatment. Thereafter, again in the month of August, September, I was taken to a psychiatric for OPD treatment, and I was also prescribed medicine for sleeping disorder. I do not remember when I filed the petition before the court for medical treatment. It is not a fact that I have become an approver in order to save myself and to blame on others. Exhibit 76. Now, then, my lord, the cross-examination is by Vanlal Chana. I could meet Malsakimi several occasions prior to the meeting of Vanlal Chana. I could meet Malsakimi several occasions. After meeting Vanlal Chana, I never had any direct dealing with Vanlal Chana in any occasion. I could meet Vanlal Chana twice incidentally. Vanlal Chana never directly entrusted to exchange money. In the first occasion when I met at Calcutta Hotel, it is Malsakimi who introduced me to him. I do not know whether they occupied the same room. I have been introduced by Malsakimi, so and so, not important. Then cross-examination by Khojinder Hojai. Certain portion, my lord, I will deal when I will refer. I argue Khojinder's case, otherwise there will be duplication. I don't want repetition. But then this is important because I have made a submission regarding this. I have not submitted any document regarding a state. I'm reading at page 60.
Yes, yeah,
I have not submitted any document regarding a stay at Calcutta or had doing any business at Kolkata. I do not have any license for doing the business for exchange of money. The business of exchange of money for me was an illegal business. That is why I do not have any receipt regarding the same. Prior to identification of the accused for first time in the court on 25/11/2013, I was shown photograph of accused by NIA official during investigation. So before 2008, I was not known to Khojinder Hojai. I did not give any description at the time of giving my statement under 164 before the magistrate, such as color of the person, height, age, caste, face, appearance of the person, whom I identified before the court as Khojinder Hojai. I have never had any direct dealing with Khojinder Hojai. Khojinder Hojai had never directly entrusted any money to me for exchange. I never meet Khojinder Hojai earlier at any occasion. I'm not trying to implicate Khojinder Hojai in this case. It is not a fact. It's a normal melody.
Yes.
Now, my lord, this is the evidence of an accomplice. If my lords can kindly come to section 133 of the Evidence Act.
Yes.
The expression accomplice has been explained. An accomplice shall be a competent witness against an accused person. And a conviction is not illegal merely because it proceeds upon uncorroborated testimony of an accomplice. This is what was made in 1872. Then my lord will kindly come to section 1, section 14. Section 14 or 114? It will be 114.
114.
Yes.
Presumptions.
Page, paragraph, section 114, my lord.
Yes.
The court may presume existence of certain facts. The court may presume the existence of any fact which it thinks likely to have happened, regard being had to the common course of natural events, human conduct.
Clause B.
B. That an accomplice is untrustworthy of credit unless he is corroborated in material particulars. Now, I have some decisions on the point, my lord. My lord, I'm referring to, I've given you no copy of the compilation of judgment. I've given you. At the time of bail, we have given you the copy. Public prosecutor was there, I don't know. My lord, the judgment, though, I had given him copy. He said I was not then public prosecutor. I said I had given to public prosecutor, not Mr. Chaudhary. All right, the decision that otherwise I would have said the decision. 1969, 3 SCC 429.
1969.
1969, 3 SCC 429.
Yes.
Mr. Chaudhary is a gentleman.
429. Mohammed Hussain Umar Kachra.
Yes.
Yes.
My lord may come to paragraph 21. Next page, 65.
Yes.
On the merit, we find that the two courts have recorded concurrent findings of fact. Normally, this court doesn't reappreciate the evidence unless the findings are perverse or are vitiated by an error of law or there is a grave miscarriage of justice. The courts below accepted the testimony of accomplice Yusuf Merchant. Section 133 of the Evidence Act, then it is quoted, which I have just placed, I can skip. Illustration B to section 114 says, court may presume that an accomplice is untrustworthy of credit unless he is corroborated in material particulars. Combined effect of section 133 and 114 illustration B is that though conviction based upon accomplice evidence is legal, the court will not accept such evidence unless it is corroborated in material particulars. The corroboration must connect the accused with the crime. It may be direct or circumstantial. It is not necessary that corroboration should confirm all the circumstances of the crime. It is sufficient if corroboration is on material particular. The corroboration must be from an independent source. An accomplice cannot corroborate another. And then the decision. Then the next decision, my lord, will see at page 66. 1977.
Dagdu. Yes.
My lord. 77, 3 Supreme Court, SCC, page 68. Again, paragraph 21. Next page, 67. There is no antithesis between section 133 and illustration B of section 114 of the Evidence Act, because the illustration only says that the court may presume a certain state of affair. It does not seek to raise a conclusive and irrefutable presumption. Reading the two together, the position which emerges that though an accomplice is a competent witness, though conviction may lawfully rest upon uncorroborated testimony, yet the court is entitled to presume and may indeed justify in presuming in generality of the case that no reliance can be placed on the evidence of an accomplice unless the evidence is corroborated in material particulars by which it meant that there has to be some independent evidence tending to incriminate the particular accused in commission of crime. It is hazardous as a matter of prudence to proceed upon evidence of self-confessed criminal who, in so far as approval is concerned, has to testify in terms of pardon tendered to him. The risk involved in convicting an accused on the testimony of an accomplice, unless it is corroborated in material particular, is so real that real and potent, that what during the early development of law was felt to be matter of prudence has been elevated to judicial experience in requirement or rule of law. All the same, it is necessary to understand that what has hardened into the rule of law is not that the conviction is illegal if it is proceeds upon uncorroborated testimony of an accomplice, but that the rule of corroboration must be present to the mind of the judge, and corroboration may be dispensed with only if particular circumstances of the case may be safe to dispense with. So discretion is left to your lordship with a lot of caution. But as I have submitted earlier, he is not even an accomplice because he doesn't well, confess his guilt. Then the last one is very important. This is not one. I am finding it little difficult. So I feel I'll tell my lord. Your lordship, I've seen your lordship does not want us to refer the name of the judge. Now, I have a little submission there. First, I will say, my lord, there was a Chief Justice here, B. Sudarshan Reddy, who was elevated to Supreme Court. Now, he will know the judgment by the name of the judge. And it became my habit. But I'm controlling after hearing, I have controlled myself. And then I submit, my lord, your lordships, the judges are known by the judgment they deliver. True. My lord, today, Justice H.R. Khanna's portrait adorns court number 2 of the Supreme Court because of one judgment, my lord, ADM Jabalpur, my lord.
That's
so therefore, sometime, my lord, it comes out.
very
So I thought I will definitely, my lord.
Please carry on. Please carry on. As you like. Yes.
The next is, my lord, 2014 8 SCC page
See,
3.
that observation is in the context that many a times there are demeaning kind of words associated with the name of the judge. That is when it comes out, you need not
Yes.
refer to that.
Well, there is, I've read, I don't remember offhand, but what is not permissible is you cannot attribute motive to the learned judges.
That's right. That's right.
Because what, my lord,
You may
today,
criticize a judgment, you can't criticize the
Yeah.
judge. Basically.
there, my lord, again, I have something. Because once we criticize the judgment, it will very difficult, my lord. Because once I'm reading something, your
The
lordship.
fine line has to be
think.
drawn somewhere.
Yes,
Yes.
line has to be drawn because motive cannot be my lord, attributed because I'm representing a partition, one party, my lord,
Yes, that's true.
and your lordship has to see both and dispense justice, my lord.
Just in that context,
Well,
we had one honorable judge transferred from Madhya Pradesh, and is a absolutely fine judge. So he was the acting chief justice for a while, and people used to go and complain to him. The lawyers are indulging in bench hunting. So the reaction which he gave in the court was wonderful to hear. He said, "What is this nonsense about bench hunting? A lawyer has a vested interest in his client. If he finds that there are two different opinions available, he has every right to search for the one which is favorable to him. And so judges has got no vested interest. Why are we interested in hearing that particular matter? So the lawyer has every right to look out for the better option." Yes.
Now, my lord, in this case, which
You
I'm
are referring
referring
to?
to, this is 2000 volume 5 SCC.
2014.
Oh, sorry. 2000 volume 5 SCC 440. 440.
Yes, serial number?
My lord, 52 of the compilation.
Yes.
My lord, this is State of Tamil Nadu versus J. Jayalalitha.
Jayalalitha. Yes.
Now, page 56, if my lord will relevant.
Yes,
will
please.
be page, paragraph 10 and 11. I'll page,
Mhm.
at page 556. Thereafter, learned single judge proceeded to consider the statement attributed to third accused Venkat Raman as recorded under section 164 of the code and found that the said material is not capable of being converted into legal evidence later on after framing the charge. Here, my lord, Jai Jayalalitha was discharged from the case and the state has come up against the discharge. The 11th is important, my lord. We may at the outset point out that there is no use of the said statement attributed to the third accused, Venkat Raman, on account of two reasons. First is the said author of the statement has already been arraigned in the case and charges have been framed against him. Second is that on reading his statement, we have noticed it is
Exculpatory in nature.
in nature. Hence, the said statement can only lie in the store and no court
No court can
possibly treat
treat us.
it as evidence. And this is exactly the case here. My lord, I have submitted before your lordship after placing a few portion of PW 29 statement that it has no corroboration. But the learned, my lord, trial court has discussed George in 34 number of paragraphs of the judgment. 34 numbers. And the learned court, my lord, found that 8 prosecution witnesses have corroborated PW 29. Now, who are these 8 prosecution witnesses? I will say, my lord. PW 18.
Before we proceed there,
Yes.
probably
My lord.
you missed out a very interesting 2 lines from the statement of George.
My lord.
Says that I had, or whatever you can say, I've had the advantage of having worked on the trial courts for all my years of advocacy. So there was a habit of course, indulging in the exercise of hair splitting. And there's every right of the lawyer to do that. Mr. Chaudhary, come to page 61. That is the internal page 5 of George.
Page 150.
You have it?
Page 152 of volume book 1, paper book 1.
The statement which a witness gives is supposed to be on his own personal knowledge, right? Read what he says. This Mr. Mishra also missed. Read out aloud.
Lordship is referring to the
Cross-examination for Malsakini. Read the first 2 lines only. What do we make out of that?
I have given evidence in this court on the basis of confessional statement at the time of investigation while I was in judicial custody.
So he makes it very clear that whatever he has stated is on the basis of the confessional statement, not on his personal knowledge. So what is the worth of this statement? Leaving apart all other arguments.
This I missed. I was one day, my lord, witnessing, my lord, the proceeding which was on here. And the matter related to whether father is from different caste or mother is from different caste, and whether the girl will be entitled. And everyone, including both the council and the court, missed one very particular thing in the judgment, which your lordship pointed out, where she was brought up. The situation in which she was brought up, the circumstances in which she was brought up. If she was brought up in that, then she will be entitled. And this is the second occasion which I have noticed I missed that.
It happens. You have been probably going through this evidence n number of times. So sometimes it becomes a matter of routine and boring kind of thing.
No, it just is skipped, my lord. Normally I make note, but it is skipped. I confess.
So
now, my lord, 8 with prosecution witnesses.
Let us see those witnesses. Yes.
My lord, first with
PW 18.
PW 18. Now, PW 18 is manager of Madhu Milan Hotel.
38.
Yes. 38.
Yes.
But I'll just preface, my lord, what he has said. He is an employee of Madhu Milan guest house, actually it is, but hotel is written, at Calcutta.
Mm.
He comes and places some register newspapers and says that Fajinder Hojai was
Used to
staying in
come,
the hotel.
used to
That's all.
come. Yes.
This is what he says.
Mhm.
I'll play it.
But does he identify Fajinder Hojai?
No, no, no. No, one of them have identified. And the
Okay.
question was, how do you remember? Because after about 8-9 years, he said so many persons come, but he said, I recognize. I'll place at page 38 now. I have been working in Madhu Milan guest house at Bada Bazar, Kolkata since 2003. I'm still working in the same guest house as manager. The guest house for providing accommodation to the customer. The proprietor of guest house hotel is so and so. We provide only stay in the guest house. The guest house has entered their names in the entry registered meant for guest house so and so. Exhibit so and so is the guest house registered maintained by Madhu Milan guest house with effect from 1910-2008 to 16-3-2000. It should have been 16-3-2008
Mm.
to 1910-2008.
Mm.
His period is not concerned. It doesn't concern. Under objection, so and so. Because it was a loose sheet, so therefore it was objected that it is a loose sheet. Serial number so, one Fajinder Hojai from Haflong, he came and stayed. Then my lord, in the cross-examination at page 39 say it is correct that exhibit 50 are all loose sheets of paper which are not paginated or bound. Exhibit 50 does not contain any seal or signature of any officer. My lord, this way, these four are the employees of the hotel,
very-
and they say,
Very same guest house.
no, other is from Shalimar Hotel.
Okay.
The two witnesses are from Madhu Milan and two are from the Shalimar Hotel. My lord, assuming for a second that they have been able to prove
That
that
Fajinder
he
Hojai
was there. So he
visited
was there.
Kolkata. Yes.
On material, my lord, point that if they had made a statement, yes, I have seen A9 came, took money from
Or
A1.
even met.
Even met.
So
Nothing is there.
taking money is a different part. Some
Yes.
whether there was a meeting.
No, there's nothing, my lord. I can place all the.
Let's see all the
No, I'll
witnesses.
say. Now I'll place 58. 58.
Page
PW
58.
58.
PW 58.
PW 58. Yeah, PW 18 I have placed. Page 156.
Yes.
PW 58 is at page 154.
Dinesh Vora,
Dinesh Vora.
154.
He is from Shalimar Hotel. From 1991, I have been working in Hotel Shalimar, so and so, so and so. Exhibit 255 is the visitor register of Hotel Shalimar, 3 SN Banerjee Road, Calcutta. The entries are from 1/4/2008 to 21/2009. The register filled up by customer in their hand and put up initial in the signature column. The serial number is so and so relates to customer Fajinder Hojai. Nayanpur, Ganesh Guri, Dispur, mobile number so and so. Father name is Surja Hojai. His check date is 18/1/2009 at 2:30 PM coming from Guwahati, going back to Guwahati. He checked out on 21/1/2009 at 6 PM. His bail is so and so. Exhibit 55-2 is another visitor registered from 21/2009 to 10/7/2009. The serial number of the registered is 1615 of 3/2/2009, relates to customer Fajinder Hojai, PO Haflong, district so and so. His check date is 3/2/2009 at 5:30 PM coming from Guwahati, going back to Guwahati. He checked out on 4 at 3:30 AM. On 10/3/2009, said Fajinder Hojai again checked into hotel. The serial number is of the registered is so and so of 10/3/2009, which relates to customer Fajinder Hojai, Jew Road, Ganesh Guri. The check date is 10/3/2009, coming from Guwahati, going back to Guwahati. He checked in on 14th, he checked out on 14/3/2009. Exhibit 255/5 is the bill from room number 10 in the name of Rajinder Hojai. The bill was prepared by so-and-so receptionist, his signature, etc., etc. Then exhibit 255/8 is another bill for room number 5 in the name of Rajinder Hojai. Bill number so-and-so. The bill was prepared by Sanjeev Kumar Arora, manager of the hotel. Not relevant, my lord, according to me. 2055/11 is another bill. These are bills which he has. Then your lordship will kindly come to 430-156 stock examination. I have not submitted any document regarding my identity as well as proof as to whether I am working in Shalimar Hotel, Calcutta. I have not taken identity card of the customer at the relevant time of admission of customer in our hotel. Exhibit 255, it is a fact that in serial number of the registered 159, the name of father of the accused is late Suryo Hojai in father's column, and address of the passenger of the customer and in the said registered in the column of signature of the passenger are differed in comparison to signature and the name of the father. Exhibit 255/2 of serial number so-and-so is different. Signature and name of the father, serial number so-and-so is different. The signature of the passenger customer in the column passenger signature appears to be substantially different. This may be of two different persons, I do not know. Exhibit 255/5, 8, 11 are carbon copies because the original copy is given to the customer at the relevant time. The bills exhibited by me today are not prepared by me. It is not a fact that I am authorized to prove the aforesaid bill. NI authority did not seize the hard disk of the computer generated bill of exhibit so-and-so. So this is the second one. And the third employee of the hotel who is said to have corroborated is my lord. 69, my lord, PW 69 and 136. PW 69 is Shiv Kumar Pandey. He is from Madhumilan Hotel.
Page 165.
Page 165.
Yes.
I was, in 2009, I was manager of Madhumilan Guest House, so-and-so, so-and-so. Exhibit 50 is the guest house registered of Madhumilan House starting from March 2008 to 15/10/2008. On 13/3/2008 at serial number so-and-so, one Rajinder Hojai occupied room number so-and-so of the hotel showing his address so-and-so, so-and-so. The occupant has filled up the column stayed in the hotel on from 13/3/2008 to 15/3/2008. Exhibit 52 is the said entry, accused Rajinder Hojai. He identifies, is present in the court and I identified. But your lordship will kindly mark the date. This has got nothing to do with the present case. The date is 13th of March 2008 and 15th of March 2008. The allegation here starts with January 2009, when Mohit Hojai took over. Then exhibit 52, I'm reading 166 again. Exhibit 52 is the pointing out memo by which one George Lamthang pointed out the guest house to the police as he came to meet the person at the guest house. The same was written and I put my signature so-and-so. Your lordship will kindly see, I don't want to miss this. Exhibit 52 is pointing out memo by which one George Lamthang pointed out the guest house to the police as he came to meet the person at the guest house. Somewhere it is written that he came with the police. I'll paste that. Exhibit 53 is another pointing out memo by which one Malsa Kini pointed the guest house to the police as he came to meet the person at the guest house. The same was written and I put my signature. One Kamlesh Pandey is also manager of our guest house. This is PW 18 minutes, Kamlesh Pandey. On 10/7/2009, on requisition made by the police, he has produced the guest register number so and so, so and so, so and so. Exhibit 51 is the said production method. Now cross-examined by Fojinder Hojai. I do not know who has written documents exhibit 51, 52, 53. At the relevant time of practice of taking ID card of guest house was not started. And hence we did not insist on copy of the ID card from the concerned customer. The hotel register which was exhibited by me today does not contain serial number, not bounded one. I have not submitted any document as to show that I was manager in 2009 of Madhumilan Guest House. I have also not submitted the trade license of Madhumilan Guest House. Serial number so and so did not contain any signature of the customer. When he left the hotel in column, serial number so and so did not contain signature of the customer when he left the hotel in the column of signature. I do not know the contents of exhibit 51, 52, 53. The NIA official only asked me to put my signature and I put the signature. In the year 2009, only once I have seen the accused. Thereafter, during 8 years of gap, I have not seen the accused during this investigation period. I have also meet several thousand of customers at our hotel. So it is not possible for me to identify each and every customer, whoever used to stay in our guest house. But I can identify some of them. It is not a fact that because an NIA official has told me accused before this court, for which I identify the accused. It is not a fact that accused, then these are all suggestions, my lord. Then my lord will come to page 167. 167, same.
Yes.
It is correct that no accused person present today before this honorable court had ever visited our guest house, including the accused Sandeep Kumar Ghosh or Devashish Bhattacharya. Fojinder was must have been also there because
On page 166, this is in context to the other accused.
Yes.
On page 166, he says, it is not a fact that the accused Fojinder Hojai did not stay at our guest
Yes,
house.
that,
So that answer has been elicited. This answer is for the remaining accused.
Yes.
We have to read it in context of
yes.
that.
Now, my lord, all said and done, the only thing that is coming out, if at all your lordship accepts each person, because Madhumilan though is not concerned, the period is not concerned, 15/3/2008 to 15/10/2000, we are not concerned with the period. But even if your lordship, my lord, accepts this, then it is relevant only for the purpose that A1 stayed there.
He stayed in these two
Nothing
hotels.
beyond, nothing beyond. So it is not a corroboration on the material fact that he met those and collected money. Then, my lord, the last one is PW 136, 136, my lord, page 224.
Yes.
Page 224. I had been working in Hotel Shalimar situated at so-and-so. On 13/8/2009, I was on duty in the said hotel and police person brought some person, a lady to the hotel, and after discussion and interrogation, they prepared a memorandum which I have seen in the court exhibit.
So identification of the place by
That's why I was-
Malsakimi and George,
I was
both.
telling my lord that I have read, it says that police brought them. Not the identification. In any case, my lord, this cannot be said to be in the exclusive knowledge that it will be a pointing out memo under 27. The same was prepared in my presence and signature of so-and-so who was a cashier of the hotel, who has now retired. Signature of the lady Malsakimi was taken and I have put my signature there on. Exhibit 259 is my signature. Exhibit 259(4) is signature of so-and-so. I identify.
Perhaps
signature
the
of-
question which would be
My lord.
which would require answer is whether pointing out of the hotel
Yes.
by the two accused, what is the incriminating fact in that?
There is-
They know that there are two hotels by this name, that's all.
Everybody knows. My lord, I understand if it is your lordship said, my lord Chief Justice said that place of occurrence. Yes, the murder has taken place. That place is shown. the mud and everything is taken, sent to serologist. Serology
If
gives
some incriminating
Yeah.
fact, recovery of incriminating fact is
Incriminating
essential.
Yes. So these are the 4 witnesses who said to have corroborated PW 29. Then there are other 4 who said to have corroborated. Now, Lord, I don't think I'll have to take your lordship through this. One is Mr. C.P. Fukan, who is the executive magistrate, who has signed
Identification.
identity 77 and 119. Similarly, my lord, PW 59 is a DSP of NIA. Third is PW 63, he is a CID officer, DSP CID from Mizoram.
He is also signatory to those documents.
He is, my lord, he's not the signatory, but he is, my lord, the learned trial court has said that he has corroborated his. But CID, he will not have any personal knowledge. Where is the question of corroboration? He's in Mizoram. He will not go and corroborate that they came and met Kujinder Hojai in the hotel. And then, my lord, the IO 146, one of the IO, Swam Prakash Pani. The police officer and the magistrate, their evidence will not be treated as a corroboration evidence on material fact. Therefore, my lord, I will not waste your lordship's precious time, my lord, referring to these. If required, I will refer it later when I place the other. Now, at this stage, my lord, I would like to point out that all these efforts that have been made and the story that has been weaved, that money was defalcated, brought to Guwahati, from Guwahati it was taken to Calcutta, Calcutta it was given to A2, A3, A4.
Converted.
Then they gave it to A1, then A1 handed over to A9, then A9 handed over to A8, then A8 is an arms smuggler. He converted into, he procured the arms. So these story.
The most incriminating step is when A9 hands it over to A12, 13, 14 for procuring the arms.
And
that is where the incriminating part comes.
And also, below, if there is an evidence that at the instance of accused number 8, the weapons were recovered. Because the learned trial court himself held that the disclosure statement exhibit 43 was obtained after recovery. But at the same time, he says, but fact remains that accused has pointed out and that materials were recovered. And then he relies on post-crime conduct.
Recovery of what?
Weapon, arms.
Arms. At the instance of
Accused number
alleged
8.
Accused number 8.
One Lal Chana. The so-called arms smuggler.
What is the what hoard of weapons was recovered?
Some M20, some obsolete weapon these days, man. It was not even, but yes, AK-47, pistols, then some communication. I'll place, fellow. I'll place. I'll place when I go there. Because they have, my lord, I will, my lord, show that the entire things which has taken place creates a grave doubt on the prosecution story. Because the Caesar list, they are calling it recovery memo. It doesn't have signature of the of Banal Chana, accused number 8. The 2 independent witnesses, I'm just giving my lord that. The 2 independent witnesses have not been produced in the court. The seizure is affected after the search warrant was obtained. Search warrant was obtained. My lord knows under 165, the police has power to go and seize from anything. They will have to only record reasons. And that too, under section 27 recovery, it's so important. It has to be done immediately. And the IO who signs the Caesar memo, he is nowhere connected with the case. He is an SP who has not even been examined. The independent witnesses have not been examined. And my lord will surprise, the weapons were recovered from a house belonging to one of the witness of the recovery, Mr. Lal Rova, from a part of the house which he had rented to one lady Nampui. These are allegations. I don't know whether it is correct, but even Nampui, my lord, was not examined. She was not made an accused. And if it is in somebody's house and it is recovered, how can it be in exclusive knowledge of any person? That exclusive knowledge definition will have to be again rewritten. So, my lord, I was saying this, everything has been done to implicate these persons. I think the NIA Act came into 2008. And this may be the one of the first cases.
First initial investigation.
Yes,
So as they faltered in the NDPS Act, the initial few years, formative years,
yes.
leaving room for the lawyers to exploit
My lord,
their mistakes.
in one of the NIA cases from Manipur, it was tried here. I had moved a bail application for one of the persons, and this additional solicitor at that time, very important, additional solicitor general came. He was taken up before the division bench, and he objected, my lord. He got his picture, and I got bail. That's reported case. And if your lordship permit me, I'll name, the bench was presided over by Justice Mazhar Lahoor. Now, my lord, I'm saying, with all seriousness, that this has been done to implicate accused number 8 and also other accused. And I will show, my lord, from the evidence on record as to how he has been implicated. My lord will kindly take PW 146. He is a police officer. Paper book 3.
Swayam Prakash Pani.
229. My lord, his relevant statement, which I am referring, my lord, is at page 231. My lord got it. 5th paragraph.
Mobile number.
Similarly, mobile number 9903234905 of accused George Lamthang. In bracket, your lordship will see subscriber ID Mohit ho jai. With service provider Airtel was analyzed and printout of relevant parts taken under signature. Exhibit 434 is a scrutiny report of the said mobile. And so are the CDR of the said mobile. All these mobile phone analysis led to have evidence interlinking the accused person in pursuance of the criminal conspiracy. The detailed analysis of CDRs have stated how during the seizure of money, accused persons were in touch. It also revealed international calls made to other accused based on outside the country. Now I will show, my lord, take your lordship straight to exhibit 434. What they said is correct. Exhibit volume 8 paper book. Exhibit paper book 8.
How does he say that this is a mobile of George Lamthang? It was seized from him.
That is not very clear. But I will definitely look into it.
Because the question which arises immediately is, George Lamthang doesn't say that I had any mobile which I was seized or I gave it to the NIA.
Yes.
He doesn't say.
Yes, he doesn't say. And seizure list, I try to find out. It's such a big thing. Now, my lord will kindly come to page 1705. There's a scrutiny report of the CDR. My lord got it. CDR analysis of mobile number, same mobile number is there. Then period for which analysis is given, name of the service provider, Airtel, name of the subscriber. According to PW 146, it
Thomas
is known
Sienberg.
Thomas Sienman, for a BPO Chudra Chandpur. So how am service, this mobile they are alleging? They are alleging falsely. And my lord, this was placed before the learned trial court. And trial court, my lord, rejected these, saying that there is no 65B evidence act certification, therefore these are rejected. And my lord, I will just take your lordship to paragraph 77. He has said this in while dealing with A1. He has said the same thing in dealing with A3. At page, my lord, 47 of my lord's internal page 47 of the judgment.
Hmm.
47 of the judgment.
Yes.
Well, 74, 75, he discusses everything. And then 77 is the finding at page 48.
Yes.
But it appears
Hmm.
that CDR, as stated above, are not collected from service provider in accordance with law, and no certificate under 65B of the evidence is appended thereto. This being the factual position, the same cannot be relied upon in view of the judgment of the Honorable Court in Anar PV versus Bashir and others. So there is a clear finding. But what surprises me is, while concluding the evidence against A3, the learned trial court holds something else. Your Lordship will kindly come to paragraph 127 at page 67.
Page 67.
67.
Yes.
Internal. I'll just read the first three lines of 127 and then go to the relevant portion. The accused has cross-examined, my lord. The accused has cross-examined the witnesses mentioned here in above, but nothing tangible could be elicited to discredit him. On a dispassionate analysis of the above evidence, the facts and circumstances appearing against the accused can be recapitulated as under. Then your Lordship will turn to 7, my lord, at page 68, Roman 7. George Lamthang, who was instrumental in converting money to US dollar at Kolkata, possessed mobile number so-and-so. Subscriber ID of the same was Mohit Hojai as service provider of the Airtel. Now this finding after, my lord, recording a finding that these are not admissible and seeing 434, exhibit 434, which clearly says that
This finding is basically in relation to the
Mohit Hojai.
The subscriber ID. It is in, of course, contradictory to the document.
Yes.
But this has nothing to do with 65B. It's only in relation to who is the subscriber of the mobile phone.
My lord,
But the document speaks otherwise, as your point.
but paragraph 74, 75, he had discussed these. I have not placed
He has
that.
discarded the call detail records.
Yes.
But the subscriber number that is there, that you may be right in saying that even that document can't be
Cannot be looked into
looked into. Yes.
because that is part of the CDR.
Syria, yes.
Exhibit 434 is part of CDR.
Yes. More so because George Lamthang himself doesn't say
Yes.
that I possess any
Yes.
mobile number
Well,
with that number,
well,
any mobile instrument. Yes.
Now, the 8 acquisition I'll come to. My lord, that is A9 handed over dollar to A8. There's no evidence, as I have said before your lordship. So there is no evidence. He may show the evidence. And then, of course, if it is correct, I'll stand corrected. Now I come, my lord, to the most crucial part, according to me, my lord. Accused number 8, Banlal Chana, after receiving the dollar, procured the arms and delivered to DSDK. This is most crucial. Now, the first question, my lord, after going through all, I asked myself is, who is Banlal Chana? Because he is being called as arms smuggler. Everywhere your lordship will find. Now, a person doesn't become arms smuggler because some of the officer of the NIA start calling him arms smuggler. There has to be some solid evidence. And that evidence will be in form of a conviction. Or even if, my lord, there is no conviction, he has been tried for smuggling of arms and has been given benefit of doubt on technical ground. Yes, you can call him arms smuggler. But there is nothing. They can show, my lord. Even an iota of evidence, even a sentence by any of the witnesses, independent witnesses, I'm talking, that he is an arms smuggler. So, my lord, to say that he is an arms smuggler, that was the point which they were harping, my lord, at the time of bail. He is an arms smuggler. He is a known arms smuggler. But there is no evidence. This is the first thing which I would submit before your lordship. Now, my lord, the allegation is that pursuant to the conspiracy, A8, that is Banlal Chana, he procured large quantity of arms and communication equipment, and at his instance it was recovered. And they have pressed into service a disclosure memo, which is Exhibit 43. Exhibit 43, my lord, will find Exhibit Paper Book 1, page 79. My lord, I would have, in normal circumstances, I would have taken away straight your lordships to that paragraph which says that this was recorded after recovery. But since the learned trial court has held that this was in exclusive knowledge, I have to refer this. Exhibit 79, page 79, Exhibit 43. May I read if your lordship is permitted?
Yes.
One Lal Chana, one Tia, all these allies he has denied, my lord. His passport they have seized, it's only one Lal Chana. But then they are giving these alliances. So-and-so, son of so-and-so, voluntarily disclosed in the presence of, if your lordship go by the sentence, it is already disclosed. Disclosed in the presence of independent witness, namely Lal Robha. My lord will mark it, he is the house owner of the house. Son of so-and-so, he has not been produced. Then Joming Thanga, who is he is not clear, but he has not been produced as a witness. Son of so-and-so, that a deal was struck between DHDJ and John Mijo and John Silas to supply arms for the use of DHDJ at an insurgent group active in NC Hill. Now, this will not go under 227. This will be hit by 161. It came to my knowledge from one Thanga of Tahan, Myanmar, that a consignment of arms containing M16 assault rifle and other communication equipment has been dispatched by him meant for DHDJ. So he is relying on someone else's evidence who has not been produced. The said consignment was kept concealed in the house taken on rent by one lady Nampui. I can identify the said house in Sarangweng area and lead the recovery of the said consignment. I'm giving this disclosure voluntarily without any pressure. Now, my lord, this will not be a statement under
27.
27. So this is in someone else's house, owned by someone. It is on rent taken by a lady. It cannot, by any stretch of reasoning, it cannot be said that it is in my exclusive knowledge. So no question of this being a disclosure memo as contemplated by section 27. My lord, there are 2-3 decisions. I'll place.
Where is the memo of recovery?
My lord, memo of recovery, yes, exhibit 250.
Let's see that simultaneously.
At page 1154, exhibit volume 5. Volume 5. Well, before that, 1 second, if your lordship can go to 43, I've just played.
423.
No, 43, exhibit 43, disclosure statement which I have just played.
Yes.
One thing I just want to show. My lord will see this statement is made in connection with which case, and your lordship will note.
238/2009, Aizol.
Aizol PS case number 238 of 2009. And this is not recorded by the IO of this case.
Of the present case.
Yes. No, not present case. The present case, yes. But even this is recorded by a CID officer who has nothing to do. He has made a statement that I have nothing to do with Aizol case 238 of 2009.
One more important thing, sir.
We'll
we'll have a look at the date of the recovery.
Yes.
But this disclosure doesn't even, so-called disclosure,
yes,
doesn't indicate that the witness, the accused said that I can lead you to that place.
Yeah.
That is what the essence of 27 is.
Yeah, your lordship is absolutely, I'm sorry, that mouth, such an important thing. And let the recovery, he didn't say, your lordship is.
And lead the recovery of the
Yes.
said consignment.
Yes. Well, therefore, I said also firstly when I appeared, law is such a subject. Where every day, my lord, I learned.
My maternal grandfather, he was the leading lawyer on the criminal side.
My lord.
He would keep this major acts with himself every moment, and every day there was a fresh underlining.
Well.
And he would tell me that each time you look at the section, you learn something new. That's how things are. Page number?
Page number 1154. This is exhibit paper book number 5.
Double 154 would be in this. इसमें भी है क्या? 1154 is there in that one also. Okay. So this is madam's that I about. No. Yeah, this is your set. Yes, yes.
1154, my lord.
Mm-hmm.
Now your lordship will see, start from the first line. District
No FIR number.
No FIR number, no case number. Then just below that, if your lordship will see, in pursuance of the warrant
To search suspected place issued by magistrate.
suspected place issued by the magistrate first class. This we have not got. We checked up the record, it's not there. And this was issued on 30th of July 2009, my lord. Then, if your lordship will see, witnesses. First, my lord, description of the place of seizure or recovery. That 4D. From the residence of Nampui, care of Lal Roha of 7 Leng, Aizawl. Then, my lord, will see next page. This is recovery. There is no separate seizure list, my lord. Recovery. M16 rifle at page 11.
This is the seizure memo. This is the
There is
seizure
no
memo.
seizure memo, my lord. That's what I'm.
This is the seizure memo.
This is the seizure memo. That's right. Recovery, they say this is the seizure memo.
The property search and seizure.
Yes.
The documents
My lord.
says seizure form
Yes.
under section 165
My
CRPC.
lord.
Yes.
Now your lordship will see M16 rifles, 8 number. Number obliterated. Because, my lord, it has come in the evidence that it was not sent to ballistic expert to show whether
Serviceable.
it is serviceable or not. And then 9mm pistol, Beretta, US cop, so and so, telescope, Bushnell, walkie-talkie. These are the things which were recovered. Your lordship will kindly see the witness. The first one is Lal Roha. And the second one is Zoning Khanga. And this side, your lordship, on the right-hand side, your lordship will see signature of the investigating officer.
HL
HL
Thanks,
Khanga,
Sudha.
Additional Superintendent of Police, CID.
Mizoram.
He is a person non grata.
Person non grata, yes.
And then PW 56 has also signed. He is an HS Karnial. He is an inspector of NIA. He was present.
He was present.
How he was present, we don't know. Because this person was remanded to, according to, there are two versions, my lord, from the prosecution side only. One is by PW 14, who has made this exhibit 43. He says the day when we went to seize the arms, so that is 30th/7, Vanlal Chana was in the village. He was moving. He was not wanted in any case. PW 13 says, no, I have arrested him. And he produces a, my lord, exhibit 42, where the magistrate has discharged saying that he was arrested 4 days ago and after expiry he was produced. He was produced on 31. So all said and done, if at all it is to be believed, accused number 8 was in the custody of Aizawl PS case number 239 of 2009. How come these Karmial and others, they became a part of the investigation team in Aizawl police case 239 of 2008.
Camp Aizol.
Yes,
He must have been examined.
I will take your
We
lordship.
will see his statement when,
I'll take your lordship.
whenever, yes.
And then next stage, my lord, we'll see.
Mhm.
This will be another interesting feature, if I can say that. Handing over and taking over note. This is exhibit 251.
Mm.
I do hereby seize.
Received and seized arms.
Seized arms and ammunition as per Caesar Memo 37, 2009. In connection with NIA 1 of 2009. This is Caesar, first of all, search and Caesar Memo doesn't disclose any case. Exhibit 43 disclosure statement says it is in connection with Aizawl PS case number 39 of 2009. He says it was seized in connection.
Is
with-
that order of magistrate exhibited?
My lord, there is only one order. The other orders are not there. In fact, there was an application from one of the accused, accused
Yes.
number 4,
Mm.
to call for all those,
Doc-
but there was no order. The
No, this
counsel-
refers to order dated 31st July. That order must be there on record.
31st is there.
Yes.
31st is there, exhibit 42, and there is an application under 41. The only evidence which they have is, and which has been relied upon, is that it disclosed that these arms are meant for DHDJ. There is nothing except that statement of an accused has been relied under 161. That this is, and it's mentioned in the finding, my lord. That's what most surprising. I will take your lordship to those findings. Another thing, my lord, will see in exhibit 250, the recovery memo and search and seizure report, there is not a whisper that the arms were seized at the instance of accused number E.
That we have seen, that we have seen.
Yeah, my lord. So PW 14, my lord, he's a CID officer. He has said that Lal Roha is the owner, the first witness of the house. And it is recovered from the house of one Nampui or something. Nampui. And PW 56 also says it is recovered from the house of Nampui. PW 56, that NIA HS Karnia,
Mhm.
he also said.
Yes.
Now, what is the reason they have not produced Lal Roha? What is the reason the person who has, I don't want to use that word, but who has signed as investigating officer, what was the problem in writing what in connection with what case you are seizing case? And whether you are the IO of that case, there is nothing. He has not even been produced. Now, the only presumptions, my lord, which can be drawn is that if they were produced, they would not have supported their, that's the law. If they were produced, they would not have supported the prosecution case. That's how they have been,
One more important question.
my lord.
This HS
Karnial.
Kanyal, we'll see his statement.
Yes, yes.
What prompted him to reach Aizawl on that particular?
What he says, he was informed by his CIO, got information that one arms smuggler is arrested in Mizoram.
Mizoram. And he
Mizoram.
proceeded from which
And he
place?
was asked to go
He proceeded from which place?
from Delhi.
Delhi.
From Delhi.
So,
I'll show my lord.
no, the question is, reaching Mizoram from Delhi, even if one takes the flight, after receiving such information,
Yes.
because the Caesar memo bears the time,
He says 26/7 he was arrested.
arms smuggler.
Yes. 20, because he's relying on PW 13 statement and the order of
Arrest
the
of Vanlal Chana.
Valnal Chana.
Okay, okay.
Because that's why I'm saying his arrest itself
In
is
connection with 238.
238. And then they were informed, and they said that we were informed. And my lord, HS Karmial has gone to the extent of saying that exhibit 43 was executed, was recorded by Muizo police. He's not saying CID. And the person who recorded 43 is not a witness. He has not signed. Your lordship has not seen his name.
Lal Tanpua
Lal
Silo. what?
Tanpuya.
Tanpuya Silo.
Yes.
Yes.
He is not a witness. And he is said to have recorded the
In any event, the recovery, seizure recovery, whatever it is, it was made at 11:30.
Yeah.
What is the time of 43? Time of recording?
No time mentioned. So one thing is mentioned that when they went to recover the arms, he was free.
He was?
Vanlal Chana was free. He was moving in the village. That's why I'm saying, even his arrest is doubtful.
Okay.
All manipulated.
Okay, very well.
Let me start with Karmial on
Third.
on third. Third is third is-
First and second,
Third and fourth I've seen holiday.
no. Third and fourth are not holidays. Sixth and seventh are holidays.
Oh, yeah. No,
First
no,
is,
no.
third and fourth are working, fifth, sixth, seventh are
No.
holidays. So third and fourth, you are not available.
No, I'm here, my lord.
Third, hearing continues, list on 3rd April, 3rd May for further hearing.
That day I'll come.
First and second, I will not be available here.
My lord.